kindly. Well, may I have Lordship's kind leave to mention a matter? Well, this
For a
is
second. Motion matters, just hand over the.
well, inclusion in the list.
Motion matters, just hand over.
This is a new motion for inclusion.
New motion, listed motion, just hand over the slip first.
Well, due to extreme urgency, I am disturbing your Lordship. Well, the fact is, well, the land in question situated at Falta. Now, well, that in that land, well, there is a hostel, few hundred students stay there, and so is well, teaching staffs reside there. Now, well, without any process of law, WBIDC well, terminated the lease. Well, we are in possession of the land, but well, the urgency is that well, Lordship will see they have already, well, they have already well, put the land. I am in possession in auction that anybody can purchase the land at any point of time, even before 30 days. Well, not even 30 days has crossed. Lordship will see.
Who is the authority?
WBIDC.
Under the state.
Under the state.
What is your status here?
I am staying there.
What is your status?
Educational institute, Malad. Educational institute hostel for teachers.
How you came into possession?
Malad, WBIDC, well, at first this land was given to Associate Cement Company. Associate Cement Company gave it to me assignment where WBIDC was the confirming party. Malad, no right of resumption is also there. Malad, the urgency is this. Malad, the students, Malad, 200 students are residing there. And Malad, so is Malad, the teaching staff. Malad, if the property is anybody, any day can sell it, buy it from the portal. Malad, can it be on 2 p.m.? Malad, Mr. Mitra is leading me.
Today?
Today,
Not
Malad, a supplementary list. Malad, Monday, Malad, top of the list, Malad.
When the what is the last date of the submission of the bid in the auction?
No, it's not open. It is Malad, WBIDC. Malad is like a land bank. Anybody, any day can buy it. And another right will be created without ousting me, without Malad, any due process of law. I am stunned by a state authority.
1st July fixed motion.
1st July?
Fixed motion.
Malad, may I it be top?
Serve notice in the meantime.
Yes, I have already served. Mentioning slip is there, Malad. I have already mentioning it on
Yes.
service.
I'm taking Lordship leave to move this matter as an extremely urgent matter. Yesterday, the notice served by the PWD authority to start demolition proceeding on 1st July, the Tuesday. But the total land acquired by the PWD 9 decimals, but they have prepared a sketch map 10 decimals, so that they cannot prepare 10 decimals. So that they have fixed the date for demolition on
10-3 proceeding has been completed.
Yes,
10-3 proceeding has been completed.
completed.
10-4 completed.
Completed.
What is the date of demolition?
1st July, Tuesday. On Monday, this matter be taken up.
30th June রাখুন under the heading fixed motion.
Wait, please, Your Lordship. Lordship, this is a matter of court number 7, my lord. My interim order is going to expire on 30th June, my lord. So it has to be listed before that, my lord.
Code number 7.
Yes, Your Lordship. The
What
determination.
is lordship? Which lordship?
Lordship, Honorable Justice Partha Chatterjee, my lord. The determination has been.
Determination with me.
Yes, Your Lordship. Today
It was with.
I was with the talk to the court officer, my lord. They said that Your Lordship has the determination for
Yes.
that court, my lord.
Justice Chatterjee আমার কাছে determination. সে তো Justice সামন্ত। হ্যাঁ? When it is expiring?
On 30th, my lord. So if it can be
30th?
30th June, my lord. So if it can be listed tomorrow, my lord, for an extension of interim order.
So why are you mentioning today?
My lord,
What is your predicament?
my lord, the matter might not be taken up on 30th because it is running in the list, my lord, but it is not being taken up for quite few days, my lord. So,
Oh, yeah, it may be taken up on 30th June.
my lord, if that was not, if that is not taken up on 30th, my lord, my interim order will be expired, my lord. Kindly keep it tomorrow, my lord, just for extension.
Tomorrow is a holiday.
Try. Then, my lord, on a time may be fixed. I don't
Okay.
know because yes, your lordship, if it can be at 2 p.m. if it can be
Oh,
taken up,
nice.
my lord.
Will it be possible for you to serve notice in the meantime?
Yes, your lordship. I'll be able to serve it.
I'll run now 2 p.m. এর আগে। So মাথায় এসে মেনশন করে। আজকে তো আবার একটা বেঞ্চও আছে। আন্দান ম্যাডাম। ঠিক আছে, 2 p.m.
I'm so grateful to you,
Give me.
lordship. So, great.
Huh? Mhm. হ্যাঁ, 8 নম্বরই লেখা আছে। Yes. Call list. Who is appearing? Who is appearing? কেউ আছেন এখানে? কেউ নেই নাকি? পরে দেখছি এখন।
Your Lordship, I am appearing for the petitioner, Your Lordship, praying for release, Your Lordship. The fact is that matter should be filed under heading Group 9 residuary, but it has been wrongly filed under heading Group 1, Your Lordship. So I am praying your
Your Honor, advocate for the writ petitioner says
Ma'am, for the statement. In this matter, the interim order was supposed to get over on June 20th. My lords, my colleague had mentioned before this honorable bench on the last occasion, I was informed the file had not reached my lord's court from Miss Justice Unauthorized court, my lords. Uh, it's a no coercive steps to be taken. On the first order by learned Justice Subra Ghosh, it was directed that order had been renewed from time to time.
Respondent number 7 and 8 are the answering respondents.
Yes, my lords.
And for the state, my lord, state respondent.
Who are the respondent number 7 and 8?
It's the private parties.
They are private respondent number 7 and 8. CPAN বলছে এখানে।
Because I'm praying for an extension of the interim.
I understand, ma'am, but what is the stage of main writ petition that I intend to ascertain? Can you throw light of you on it?
Let's
What was the direction of the earlier coordinate bench regarding your affidavit, regarding your writ petition against upon the respondents?
well, it's in this matter the petition was.
এখানে তো দেখতে পাচ্ছি আবার item number 2 না?
Yes, my lords.
CPAN has been disposed of.
Yes, my lords.
কিন্তু দেখছি interim order হয়েই চলেছে। Affidavit in opposition are taken on record. Let the matter be interim order. Pleadings are complete.
My lords, it would be listed for hearing, my lords. It's what I've been instructed.
দেখি দেখি ফাইলটা দিন তো কি আছে দেখি। And 2, reimposition of the interim order. Affidavit in opposition empathy respond number 8. এটা হচ্ছে affidavit of service. Affidavit of service. Affidavit in reply. Affidavit in how many affidavit in reply you have filed? Why 2 affidavit in reply has been filed? Against the 2 separate affidavit in opposition.
Yes, my lords.
We have filed the affidavit in opposition. If you could not answer, I will not grant extension, I'm telling you.
My lords, may kindly
Don't take it so lightly, madam. I want to know who have filed affidavit in opposition.
My lords, may kindly pass it over. My lords, like
Pass it over then in the month of September.
my lords, may kindly consider.
Why you have come before this court? Only for getting extension of interim order.
My lords, the interim order was.
I will not grant extension of interim order unless you can satisfy me.
My lords, may kindly pass it over. Then I.
No, no pass over. দুখানা affidavit in reply file করে দিল। Report in the form of affidavit of response of 4 to 5. এইটার against মনে হচ্ছে ফাইল করেছি। Is it the duty of the court to find out the affidavit in opposition, affidavit's report in the form of affidavit? You don't know. You have filed two affidavit in reply, one against the affidavit in opposition of one set of respondent, another against another set of against the report of the another set of respondent.
Yes, ma'am.
If the court can search, you cannot search. You are so busy, counsel, madam. The interim order has passed earlier. ওর সঙ্গে একটা লাইন অ্যাড করে নিও তো along with
Thank you, bhai. Dekte paচ্ছি।
next item number 3.
See, my lord, here I am for the petitioner, my lord. This is for case as a checkered career. But since today is appearing for the exchange of interim order, so my lord, that was
They're complete.
complete.
My lord.
Evidence are complete. এটা দিন অর্ডারটা। ওইটি লাস্ট অর্ডারটা কেউ না আছে দেখুন তো। দাও তো ভাই। অর্ডার লাস্ট অর্ডার।
Interim order extended up to
Up to
June
30th
30,
June.
2025.
Yes.
Last order is 7th March of 2025.
CPAN disposed of.
My
The
lord,
CPAN is for
contempt.
other bench too.
Contempt, my lord.
So it is not before me.
No.
No. But it is a contempt of Justice Kapoor, and as well as we decided by the Supreme Court, my lord, unless the contempt
Very good.
application is disposed
Uh,
of, main matter can be charged.
এইখানে কেন alleged contempt না লিখলো WBT এটা বুঝতে পারছি না। এটা বোধহয় ওই টাইপোগ্রাফিক্যাল এরর হয়েছে। On page the
Like 25.
next.
But I've got the state respondent.
Extension of interim order.
What is the stage of the writ petition, sir? Exception filed.
Every pleading complete.
There was a report called for, report has been filed, and my learned senior friend, his client has also filed an exception.
The date not subject to minus convenience.
Determination of lease of the sand block.
The land was given to me for construction. Thereafter, certain stage, thereafter, coming to Lordship's court, Justice Supra was passed a direction. On the basis of that direction, make a representation. Without considering that, my lord, they ask us to give a plan. We given the plan.
ADDA are the answering respondents. Stop para. Call the next matter. Yes, yes, call. Yes. Jalpaiguri matter.
My lord, I am for the state, my lord.
Who is for the petitioner?
Well, Mr. Debashidhar is the advocate in record. He appeared for the petitioner, my lord. So if you also see the last order, my lord, there was direction upon the Madrasa to file a report, my lord.
দেখা যাক যখন ওই মাদ্রাসা ম্যাটার গুলো নেবো তখন যদি দেখা যায় ওনার ফোন নাম্বার আছে এখানে কোনো অ্যাডভোকেট অন রেকর্ডের ফোন নাম্বার আছে তাহলে যদি ওনাকে ফোন করে ব্যবস্থা করে যদি কাউকে বলা যায় যে ভার্চুয়াল মোডে অ্যাপিয়ার করার জন্য ভার্চুয়াল বা ফিজিক্যাল মোডে call the list.
My lord, the matter will appear again, my lord, Monday.
No, it will be taken up today.
Oh, my lord.
You are in Kolkata, no?
No, my lord, I am in Jalpaiguri.
Oh, Jalpaiguri.
My lord.
সারাদিন ডাকবো না item number 5 actually
See the noting of the list at serial number 1. দেখুন ওনার সঙ্গে যদি
Andy. Yes.
it will be taken up. Yes, Mr. Mitru.
May it please the Lordship.
On the last occasion, you stopped at the judgment of the Honorable Supreme Court, where the Madrasa Act was practically revalidated after setting aside the order of the Honorable Single Bench and Honorable Division Bench of this court. There is stop.
Yes. No, that is. May I now humbly submit, my lord, that question your lordship whether selection process as adopted by the commission should be nullified or should be set aside. They say it will be nullified or set aside on the ground that our division bench is supposed to pass an order restraining holding of second written test. That's what I understood, my lord, to be. Now, is the question, therefore, I deal with that question first, today, and then I would like to finish today immediately. Is there any dictum of our High Court at the single bench or the division bench that regarding the procedure to be adopted by the commission upon detection of mistake? My humble submission, my lord, there is no dictum to that effect of the Supreme, our High Court. Thus, you have seen the first order, single judge's order about question of nullity and all that, those things, let us forget for time being. And the division bench simply modified the order by extending time because the writ petition also consented.
Writ petitioner
consented to the modification by extension of time. Let's notice that. Can you see the order?
আমাকে ওই ফার্স্ট ফাইলটা আর ওই কম্পোজিটটা দাও দুটোই দিন
Page. What we get it also have a copy. Order is that is dated, my lord, 4th February 2020. My lord, got the order, my lord?
Yes, sir, I got it. Give me a second.
First is single bench.
Give me a second, Mr. Mitra.
Okay.
Yes, sir.
Second paragraph also in view of the subsequent stand, last but one paragraph taken by the appellant, do not delve to go deep into the legality and infirmity of the impugned order.
4th February.
4th February.
Which paragraph you are referring, sir?
The second page.
Second page.
Last but one paragraph. Last but one paragraph. Last but one paragraph.
Very good, sir.
In impugned modified to excellent. Whether it's good but indifferent, the question is not gone into even by the court. In direction is in terms of the order do within 6 months. Complete order within 6 months. Within 6 months, the modification of order without any opposition from the parties.
Hey, Kulanmu.
Yeah.
এটা দিন তো আমাদের রেখে। Yes.
Number the three directions have to be complied very strictly. Order says last paragraph modified to the extent that time is only extended. Directed to last line, impugned order is modified to the extent that the appellant is directed to that extent. Appellant direct to complete the exercise strictly in terms of the direction passed by the impugned order within 6 months from date. And also in view of the above, appeal and the application disposed of. Appeals are disposed of. Their appeal is disposed of by this order. There is no appeal then pending. Appeal and application are disposed of. No orders to cause. Then with my kind permission, Lordship has been order. What was the direction given by the single bench, which is to be complied with within 6 months? Also, in that matter, may I only take 1 minute for your Lordship time, see that order of honorable single judge, and see what directions were given by the honorable single judge to the upon the board. Please, minute only. This order is dated
23rd July 2018.
23rd July 2018.
Yes, sir.
Order of Justice Pratik Prakash Banerjee.
Yes, sir.
First page is the fact. Second page, the page 2, accordingly. Kindly see what are the directions given which are to be complied with strictly by the board within a time limit. Accordingly, the present petition is disposed of. After recording that, it did appear in the examination first level and on 2nd March and on the date is corrected, May 29 or not March 25, submitted by both learned advocate and Mr. Dewan, learned counsel for the commission, and by directing the response 2 and 3, I'm not going to go to defunct and all that now. The forthwith intimate first direction, intimate to writ petitioner the result of the evaluation of answer scripts. Second direction, if he is qualified, then prepare the panel in the terms of Rule 80. If he is qualified, then only. Second direction. And if he is eligible as qualified candidate in terms of the such register candidates, then the said respondent shall issue invitation letter to him for personality test. They said, evaluate his answer script. And if he is qualified, then prepare the panel in terms of Rule 80. If he is not qualified, then need not prepare. Need not prepare. If he is not qualified, then in such time and the respondent shall issue invitation letter to him for the personality test in terms of Rule 90. This is the 3 directions given below. None of the directions says that don't hold any second test or how to evaluate, how not to evaluate. And it's 3 directions are conditional directions.
That question didn't arouse that material time.
And that's right. My lord, absolutely correct. If I respect, my lord.
And
correct.
then, Mr. Mitra, what I asked the Mr. Dhar also, I am asking, can these actions be complied? Can these actions be complied with by the commission without publication of the entire result? I believe no.
No, this is not clear to me, my lord. Direction that if he is qualified,
forthwith intimate to the writ petitioner the result of evaluation of the answer scripts.
To the communicate the writ petitioner.
No, Mr. Mitra, try what
Sorry.
I'm sorry.
Very sorry.
Probably I'm not.
I'm sorry.
probably I could not explain you properly what I intend to say, sir. By directing the respondent number 2 and 3. Sir, kindly come to that line.
Yes.
By directing the respondent number 2 and 3 to forthwith intimate to the read petitioner. That is Malakar. Am I correct, sir? The result of the evaluation of sense and scarcities.
Not entire. What to it
Sir, that I intend to know from you.
Hmm.
Can a single person be taken out from the entire examining list and only his result can be declared, or this action can be done only when commission publishes the entire result? Sir, what does it mean actually?
That, as my lord said with respect and very rightly said, if I may use the expression,
Sir, had it been,
that
it is
that
a,
is, that
sir,
is
Mr. Mitra,
clear.
it is a competitive examination.
Yes.
Suppose
Yeah.
me and my staff appeared in a Madhyamik examination, higher secondary examination, graduation examination, say class 8 examination. It is possible to evaluate my answer sheet. How many marks I have got in mathematics, how much marks I have got in bioscience, biology, how much I got in English, Bengali, that can be done. But it is a competitive question, examination. Everybody is competing with each other. Therefore, their process of elimination is always there. So, if this honorable single bench, in the event single bench directed there is commission to intimate the read petitioner the result of the evaluation of answer scripts, does it not mean that you have to publish the entire result?
What Madrasa is saying is completely supported by the second direction. Second, if he is qualified, then this, whether is qualified or not, that can be found out.
On publication of the entire result.
That's what Madrasa is saying. It's a completely supported.
Absolutely, sir. That I intend to do. So, practically, the Honorable Coordinate Bench directed for publication of the result.
No, result not. Panel paper. If he is qualified, then prepare the panel. If upon evaluation answer scripts, if it is found that read petition is not qualified,
Sir, how a panel can be prepared without determining who are successful and who have achieved the cutoff marks or not?
Yes.
For a single person, a
and
panel cannot be done,
that's
sir.
the board's affidavit also. 297 vacancies. First, as my lord said,
Elimination.
first 297 will be eligible. Now, can you see how the selection process took place? Board's affidavit. Board says on the evaluation of the examination written answer script of Mr. Malakar, he was not qualified. Can you similar board's affidavit to that extent?
So, sir,
Fact.
how it is relevant for the purpose of present lease?
Hmm.
That I kindly explain. What I intend to say, sir, Honorable Coordinate Bench, when passed the order dated 23rd July 2018, does it not mean that for publication of the entire result, so as to prepare a panel will be eligible for appearing in the viva voce? That I intend to know what would be your submission.
My submission that on that date, the single bench was of the impression. Now see the method, why the result was not disclosed. First paragraph of the order. What representation?
Mr. Mitra, I'm sorry. You have to answer me on that point on. What I intend to know from you, sir, very specifically.
Yes.
From the order passed by the Honorable Coordinate Bench in Malakar space, does it not indicate that the Commission has to publish the entire result so as to comply with the order of the Honorable Single Bench? Or if the answer is yes, all right. If the answer is no, what would be your explanation, sir? That I intend to know. Thereafter, I will go to any other point.
Humble submission, Milord, that implication cannot be inferred from this order. He has not clearly said and shall support, my lord, my humble submission. Contempt.
So no implication of publication of entire result cannot be can be inferred.
No direction for publication. Number one reason.
Very good. No direction.
Reason
It
number
is your
one.
submission.
Reason
Yes.
number one. That direction to prepare the panel is conditional upon Mr. Malakar being qualified in the written case.
Sir, is it not a fallacy?
Order may be wrong. That's right. That bless the Lordship.
How can it
The
be,
order
sir?
is wrong. Maybe order is wrong. That's the order was a nullity anyway.
If the order is wrong,
Uh,
the commission has not challenged it.
Therefore, the commission has not done
I mean, it
anything.
has not been challenged.
Yes, commissioner has not challenged. Commissioner accepted this order. That's
Absolutely.
commissioner view. But commissioner acceptance will not make an order a correct order if it is otherwise not correct. that will not. They are not the judge. And if you have a nullity, nullity cannot be accepted. I'm leaving aside that question. When the court gives a direction that if Mr. Malakar is not qualified in the written test, then don't have to prepare the panel. You have to prepare panel only if Mr. Malakar is qualified, then to prepare the panel. In I cannot say, my lord, that this direction was given to prepare the panel and to declare the result of the panel. It is conditional, not absolute. This passage, my lord, has not been perhaps highlighted to your lordship. The direction to prepare panel, which is the stepping stone for preparing the results, is conditional. Is a conditional order, is a contingent order. Then prepare panel in terms of Rule 18. I am handicapped. I should not pass any order on correctness of this order because division has directed commission to comply with this order. Under this order, my lord, if Mr. Malakar was not found to be qualified in the written scripts, then commission was not to prepare the panel. Non-application mind all over. Non-application mind all over. Similar, division, under the division, if that Mr. Malakar is not qualified in written tests, then in terms of Rule 18, panel need not be prepared by the board, by the commission. If, and there is another if. That it is because of, if I may say, court attention not being drawn, that to the fact that there are other candidates other than Malakar, and there is a huge in number. Court attention was not drawn to the fact that Malakar was not the only candidate, and there are more than 1 lakh candidates involved.
Come to the second paragraph of the first page of that order.
That's
Come to this first page.
of this order. Yes,
Yes, sir.
that's
Second
what I'm
paragraph.
about to point out to you, Lord. Tell me, Lord.
In the kindly see the first last line of the first paragraph. The sentence starts with in the report.
That Mr. Dewan, Nalnet Council. That would
that
that
little below
upon
third line.
appearing with Mr.
In the report.
Yes.
Kindly read, sir.
In the report, the reason for not publishing the result of written test and given as follows.
Sir, kindly place them.
Yes, this is the chief. That's
Then,
not placing me.
The result
Court
of the
was
said
given the
written
impression
examination is yet to be published.
that it is yet to be published as the instruction by Shortwest Madrasa Commission.
So,
Service Commission.
the Malakars, the read petitioners, that is Somen Malakar's main grievance was examination was taken on such and such date.
Yes.
Result was not published.
Published
From
because
that perspective, these orders have been passed.
because the matter as referred.
Still, you say that without publication of the result, preparation of panel is possible.
And you're absolutely Miller, that is how the court mind was moving. And man, you are absolutely correct. We utmost respect because the ratio of the order of Justice Pratik Prakash is that board is not subservient to the government, state government. So, Miller, result of the written examination yet to be published as instruction has been sought by the West Bengal Madrasa. Instruction on what aspect? Was it on the aspect that mistake detected and you want to hold a second examination now? That must be instruction on what aspect? That I have held written examination of 24,000 candidates, but now we find that another 70,000 candidates are eligible, whether they should hold second examination. I mean written examination for them also. What is the instruction sought for? That may be the instruction they have sought for.
No, that was never surfaced.
Never submitted, but who can submit
That was
this?
never surfaced.
Therefore, Lordship we cannot infer.
During the
Yes.
during the pendency of the litigation before the Honorable Single Bench and Honorable Division Bench, that reason was never surfaced.
That is the question.
What instruction
So
they have
what
sought?
was the instruction? Nobody knows. But law does not float in the air. Facts of the first are submitted. So it is not open for us and for anybody to guess upon the nature of instruction which the board a commission has sought for the state government. State government, Lordship did not ask a question to the state government, commission. Commission has not said so. So that pertinent facts remain to be discovered. And my name is Lordship and saying without, it is a pertinent fact to be known, as now Lordship seen that. But not so many arguments have been made. What was the nature of instruction that was sought for? To that, Justice Pratik Prakash said that board as a commission is not subservient to state government. That's the thing. Yes, sir. But in second thought. Now, Millard, I can guess, if I may say reasonably guess, that upon finding this anomaly, the mistake upon being discovered, the commission has sought for state government's instructions regarding procedure to be adopted. Now, what is the other guess possible? All speculation. On speculation, my lord, will the employment and live blood under Article 20 on the Constitution of 297 candidates be cancelled? On speculative arguments? This argument, my lord, I'm obsessed on this it is now coming on surface. It has dawned in this proceeding for the first time after 5 days hearing. Now, let's come to the question, my lord, therefore. Is there any legitimate, irresistible grounds to come to the inference that the court in that conditional order has directed then that the result will be published for all and sundry. Even if it is found that Malakar is not successful in written examination, that is acting contrary to the order of the court. That if I now place the order of division bench also, there is no specific order of either single bench or division bench, single bench, saying that don't hold examination, written test examination for those left out candidates who have now have been found to be successful. It is a very serious matter. It has to be specific direction of the court. Single bench order and division bench order, those are two final orders, my lord. Appeal disposed of by the second order of 4th February 2002. Sorry, 2020 or 2020, 2020. Appeal disposed of finally. This is no longer pending in the court. Other orders are the nature of interlocutory orders, as my lord please stop, sir. Those are not final orders. Those are not substantive order on the merits of the case.
Then, Mr. Mittu, what have you got to say with regard to the finding of the Honorable Division Bench in paragraph
Yes,
number
ma'am,
13,
I'm just
14
coming
and
to that. I'm
15
just
in
coming to that.
13 say of the order dated 13/6/2024?
I just coming to that. I just coming to that. You know, those are applications for extension of time.
But what are the grounds for extension?
Very good. Let us see the grounds taken. Now, whether court will consider what was the risk in judicata in those extension applications. Grounds, court will see that the grounds forwarded for or placed for extension, are they valid grounds or not? For valid grounds for extension, whether the grounds are legal or illegal, that is not the question. Kindly bear this distinction in mind. Court is extending the court will only consider the grounds given, false, right, or wrong. Court, whether they are grounds for extension. Court is not going to medit of those grounds. And that is not the court's job while passing an extension of time. And court has nowhere held that grounds are illegal. I'll come into that. Now, before that, may I humbly submit a judgment has been cited by Mr. Thor regarding the effect of interlocutory orders.
Effect of?
Interlocutory orders, the Supreme Court judgment. But before that, my lord, before we go to the Delhi, may I ask your lordship respectfully to come to Calcutta and see our division bench judgment. That is more on the point. That is reported in AIR 1988 Calcutta, page 25. The two division bench judgments are there.
Paragraph, sir?
I give. Yeah, right now, give me the paragraph.
কল্যাণকে বলো
Yes.
ওটা লেখো petitioner in WPA 845 of 2025.
Yes.
Petitioner in WPA
I'm not give me the paragraph.
845 of 2025.
But yes, huh? Yes. Page 25. Yes, not kindly see that a substantial part of the
Give me a second.
relevant.
Yes, sir. Which portion you want to like?
Paragraph 6 first and I'll see the judgment.
Paragraph 6.
6 and see the judgment. Then why the question? On the merits also, we are satisfied the trial judge was justified in making the impugned order of injunction. The defendant has not yet filed his show cause against the plaintiff application for injunction. And therefore, at this stage, all the statements made in the application will have to be accepted through modo ne form. You may not agree with this observation, but said so. And when so taken, allegation is, in our view, make out a case for ad interim injunction. As and when such show cause would be filed by the defendant and the plaintiff application for injunction be taken up for final hearing, the learned judge would obviously consider such show cause and all such materials as could then be available to him. Then, in case of injunction, where the case of injunction till suit is made up, then marginally marked portion. This is marginally marked. As is well known, findings arrived at in dealing with application for temporary injunction, pending disposal of suit, even if they relate to any material question involved in the suit, cannot take the place of finding in the final decision of the suit. And if any citation is necessary for such an well-established proposition, reference may be made to the observation made by Justice Dasgupta, the Lordship, Kashi Dasgupta, Chief Justice. In the division bench judgment, that judgment I have also got, 15 CW. For sure, right. Therefore, finding, if any, made by us in disposing of this appeal against the impugned order of ex parte injunction cannot in any way take the place of finding to be arrived at in disposing of the application for temporary injunction now pending before the under trial judge. Similar, that's whatever the judgment, that is not relevant when Lordship is now giving the final judgment.
Mr. Mitra, if I say in other words, if you please permit me, of course.
Yes, no.
Does it not say that all interlocutory orders passed in a proceeding merged with the final judgment?
Merged in the
final judgment. Does it not say? Merged.
Interim order.
All interlocutory orders passed in a suit merged with the final judgment.
With respect, the doctrine of merger is confined to a final order passed by a single bench with the final order passed by the appellate court.
No, sir. I'm not on that.
That is the merger. No other.
No. What I'm on.
Final interim order cannot merge with the final order passed in a court.
Which one will prevail? Ultimately, the final judgment will prevail.
Yes. Final.
Now, in this case, sir, interim order was passed prior to disposal of the suit.
Yes.
Prior to disposal of the suit.
Yes,
I believe you will be, you will concur with me.
Yes.
Now, sir, try to understand. So, what the Honorable Division Bench said, that the finding at the interlocutory stage, a court should not be persuaded with that finding at the final stage.
Yes.
Am I correct?
Absolutely, sir.
Situation in the instant is
worse.
Similar.
In a case, worse.
Similar.
Not
because
similar. It is from my point of view much worse.
It is post disposal of the appeal.
then what's the situation worse?
It was pre-disposal of the suit or proceeding.
Correct. Suit
And it was post-disposal of the
That's
appeal.
Therefore, but this situation is worse. In that case, in this case, finally disposed of. The main lease disposed of by final order.
Yes, sir.
Whatever directions has been given in the main lease has been concluded. Main lease. By interim order, court cannot explain, change that or anything. That's it. But worst case, our case is worse. My lord say interim order may merge, etc. Those things. In this case, order has been given finally, 3 directions have been given. Question is, court can only extend the time for compliance with that direction. That's nothing, that's all and nothing more. Court has no jurisdiction to give a meaning to that order. Court will see whether ground exists, but extent of time, 6 months or 1 month, whatever it may be. That's why is the court jurisdiction in a disposal of matter to imply to or interpret or say, add something to the order passed by the court while in session of the matter? Court is not in session of the final order now. Court is not session of the petition number such and such. It is not kindly bear in mind, not most respect to submit, that it is for extension of time fixed by the court. And court will only see if the ground exists for extension of time for complying with the direction given by the single bench. 3 directions given a single bench. That's all and nothing more. Court has no jurisdiction to go otherwise. That is the first. There is no question of any obiter dicta. There is no dicta at all. Unless obiter. Court had no jurisdiction to give any directions which are not given by the court while disposing of the lease. Now, Lord, if I may now come to that order, and I respect a bit, our court has not done so, has not given any additional direction or anything, that don't do this or don't do that. My Lord was referring to the judgment order of 13 June. Can you see the judgment, my Lord? Whether that in the judgment we can at all imply that a dicta. Please, my Lord, come to paragraph 4. And see, my Lord,
Yes, sir.
paragraph 4. And similar serious omission there, here. Very serious omission. Court cannot modify the extending court cannot modify the order of the court. Cannot modify. Lordship, I think Lordship could accept this proposition. Court, while extending a time fixed by court for complying with the order passed in an appeal, cannot modify the order. Nobody applied for modification of the order. Please see below paragraph 4 now. What will the other say argue? That will amount to modification of the order.
Order 41 does not permit so.
Order?
Order 41 does not permit so.
Order 41, extending time cannot. Is a court extending the time.
In an appeal,
See?
in an appeal, Order 41 does not permit so.
No, appeal 41 is no application for appeal extension of time when appeal is disposed of. 41 applies regarding disposal of appeal. Appeal disposed of, you have shown your lordship. Appeal finally disposed of. Order 41 does not apply to the appeal disposed of. It comes the question of execution now of the order. That will be order 21 execution.
Then are you talking about that after disposal of the appeal,
Yes.
the division bench has become functions officio?
Will not
The division bench has become functions officio.
division means over the main matter has become function of issue. Because the court has fixed the time, only that court can extend the time, that is the time can be extended. Extension of time fixed by that court, that's why this court can extend. But I need not go use that strong expression, function of issue, anything. I don't intend to, but all the humbly submitting without a court after a lease has been disposed of cannot modify the order passed. It can only extend the time fixed. Order 41 Rule 33 may not applies to in a pending appeal. Court can pass such order as the single bench could have passed.
So the power to pass any degree and make any order which ought to have been passed.
Order 41 Rule that ought to have been passed. That is, in an appeal court while considering the order of single judge. Order 41 Rule.
So when the appellate court entertains an application for extension of time
Yes.
after disposal of the appeal, the division bench, then under which provision this division bench?
Power of court under inherent power of court.
Under inherent power.
Time once fixed.
So inherent power empowers the court to modify the order.
No, cannot modify the order. Only extend the time for compliance with the order.
No, sir. We have to take on one stand.
Hmm.
Either we have to take that after disposal of the appeal, the court, the division bench has become functions officio. If that be the so, the others orders need not be looked at. If that is accepted.
Good.
But if we accept that no, after passing of the division measure, after finally dispose of the division bench by the appeal, the division bench has not become functions officio, which becomes evident from the subsequent actions of the division bench while entertaining the subsequent applications. Then, sir, I believe it would be your submission that Order 41, Rule 33 has got no application. The court has exercised its inherent power. So, if the inherent power is that, if the inherent power of the court is concerned, even under Section 151 of the Code of Civil Procedure, there is large.
No. It never large. That is not that good. Power, court has fixed the time for doing something. That court can extend the time. For doing that something. At the time of extension of time, court cannot say, I extend time for
Probably,
doing.
Mr. Mitra, I could not, I failed to make you understand, sir. So try to visualize the chronology of events.
Yes.
The Honorable Single Bench passed an order, rightly or wrongly, whatever may be. Appeal was preferred before the division bench. So try to understand what I intend to say. At the time of hearing of the appeal, the appellant commission had practically chosen not to press the appeal basically. Rather, had foregone the grounds of the appeal. Yes. Their prayer was before the division bench to extend the time because of their infrastructural such blah blah blah. Now, with that finding, division bench disposed of the appeal, sir. Disposed of the appeal, extending some time to the commission to strictly comply with the order of the single bench. That you have interpreted, I have noted, sir. Now, sir, what I intend to say, when the division bench entertains subsequent interlocutory applications being separable CAN numbers for extension of further interim order, what I intend to say, can it be not called that it is an extension of the extension of the time on the basis of the finding of the main appeal, on the basis of the finding of the main appeal.
Not based on finding appeal. That
Because in the main appeal, the only order was passed by the appellate court for extension of time. In the subsequent interlocutory application, prayers were made rather for further extension of time on some grounds or other. So, sir, try to visualize the chronology of events and make your submission.
Single bench has directed completion of the directions within 14 days. The division bench said 14 days compliance is extended to modified to 6 months. That's all. The directions of that were given by the single bench are not modified by the division bench. While disposing appeal. Clear? Am I clear? Division bench, on the other hand, said comply with the direction given by the single bench and nothing more. Time is extended. Now, my lord, civil court. I humbly suggest to submit, my lord, a court which has fixed a time for doing something may, on sufficient ground, extend the time for doing that, even after the expiry of that time, to do that. That is the only thing. While extending a time for doing something, court cannot. Court has no duty to modify what is to be done. What has to be done is fixed by the final order of the division bench and single bench. It will be chaos in the judicial discipline. Order is passed by the appeal court saying that do ABC. Then the appeal court can dissolve, time expires, another division bench takes up the matter and he'll say, no, do ABC and D also. Is it logical to think on that line? Can our division bench be attributed with that intention? And the second, another ground is there.
On that ground, Mr. Dhar has argued on the point of ratio decidendi. On that ground, Mr. Dhar has argued the ratio of decedent.
Yes, they should.
On that ground, Mr. Dhar, sir, if I correctly memorize.
Ratio decidendi. Without argument, ratio decidendi of what? Ratio decidendi.
It was the submission on the part of the commission through Mr. Dhar that the ratio decidendi of the appeal is no way connected with the subsequent interlocutory applications. That was his argument.
Correct. That is different thing, right? It is extension application, interlocutory application, those cannot change the order passed finally by the court while disposing of the lease. Yes, if so.
Crux of argument of Mr. Dhar was the finding arrived at while disposing the appeal is to be looked into, and the finding arrived at by the same division bench or division B that is made while disposing the interlocutory applications need not be looked into because those findings are never ratio decidendi in the appeal itself. That was argument of Mr. Dhar.
The finding of the appeal court and single bench on the ratio decidendi, whatever, there is ratio decidendi for that finding. the subject matter of lease between the parties. Subject of lease. And that has been decided on a ratio decision, right or wrong. Single bench, appeal court. Appeal court ratio decision is, I am not disturbing the order passed by the single bench. But because
Then how do we interpret the finding of the division bench in the order dated 13/6/2024? That I intend to know, sir.
Can you see, this is the thing. Division means paragraph 13. Where division? Can you see? Kindly come to paragraph 13.
Yes, sir.
3 minutes. Division is not never said so. We are unable to accept the contention of the applicant that a plea was taken, that there has been a large discrepancy in the scrutiny process, and therefore authority have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in the written examination. We're unable to accept the contention of the applicant that plea was taken before the division bench or single bench. May I read it again? It has been
Such plea was never taken.
A plea were unable to accept what? Not that ground is plea is good or bad.
Such plea was not taken.
That's right.
Practically, that is saying.
We are not saying we are unable to accept the correctness of the plea. Unable to accept the plea is a factum that the contention applicant, the plea was taken. That court is not accepting. The plea was taken before the single bench or division bench while disposing appeal. This has been considered to be ground. They are unable to accept the plea. Very well. Therefore, court is extending the time on the basis that no such plea was taken. No such, what the plea? Discrepancy in the scrutiny. That plea was not taken before single bench and division bench while disposing appeal. Yes, correct. Apparent from judgment is not taken. But on that basis, parties are arguing before Lordship that court directed that no, second written will be held. This has to be raised properly. And having regard to the mind, that court is extending only considering whether ground exists for extension, not whether order passed by the single bench was right or wrong. See, now can you say paragraph 17 now? They have relied upon strongly. See the paragraph 17. It speaks otherwise. Similar. We would have proceeded to reject the said application. Therefore, no ground has been made out for extension of time. No sufficient ground. But considering the plight of the candidates, that is not what the Court of Equity steps in. Plights of the candidates who have participated in a written examination and because of the careless conduct of the authorities, their fate is still enlarged, or in other words, uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. Full stop. Full stop. We are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple. Then after conducting the written examination, answer script are to be evaluated. What does it mean? The division, after conducting the written examination, answer script are to be evaluated. And so,
Mr. Mitra, according to you, what would be the implication of this finding?
Implication of finding, my lord? Well, in humble submission, conducting written examination is not prohibited. On the other hand, court while extending it mentioned the word after conducting written examination. Now, next contention is whether from that can it be?
No, Mr. Mitra, I'm sorry to interrupt. Here it has been written further written test.
Further.
Yes, sir. Kindly read.
No, after conduct.
We are unable to
examination.
comprehend the stand of the applicant
Hmm.
that further written test is required to be conducted.
Required. Yeah, and to be conducted, the same was
No.
not accepted by single bench.
Then what would be your submission with regard to this finding?
This point. This is not a finding. It's not a finding. This can you see me not? This part. If it is while extending court. Now, first of all, say below, we feel that authorities must act strictly in terms of order passed by single bench and affirmed by division bench. Correct? Correct. The next, we are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by a single bench as well as division. Why is that? Which single bench order said so? Which division bench order said so? And then they add, and direction was plain and simple that after conducting written examination, answering queries. And no, they say direction of the single bench was that written examination had to be conducted. And no single bench or no division bench has said that further test, written test is required or not. Now here comes the question, my lord. It is not an obiter dictum. Not even an obiter dictum. Obiter dictum means a finding on a question of law. That is why, my lord, obiter dictum of Supreme Court is binding on High Court. A question of law is binding, not a question of fact. Question of fact is never obiter dictum. Can never be a dictum. That is not binding on any court or any party either. Now, if the order is interpreted in that manner, this order, extension order, my first submission is that extending court has no jurisdiction to any way modify the order of the single bench, having confirmed that, etc. Number two, the order of single bench and division bench disposing appeal. It cannot be implied. Mr. Dhar has made a valuable submission that we can imply something from an order if that is legal, if that is possible, if that is legal. You cannot imply from an order to say the court has directed you to do something illegal and make that order illegal. Why I say so? The fact remains that 73,000 eligible candidates have not been called for written tests. Those 73,000 candidates were not parties to this application for extension. Is it fair on the part of anybody to argue and to hold that the court, a court of justice, passed an order against non-appearing party to whom no notice was given, were not parties to the suit, fatally affecting their fate, affecting them prejudicially?
Then I am putting same question to you which I put to Mr. Dhar.
Yes, Miller.
If the conscience of the commission was so strong, what prevented them to approach the sales and division bench in the review that this is the illegality or irregularity I have committed?
Yes.
Allow me to hold the further examination.
Review when lies. Review when lies. When this review of the order of division bench or single bench, when there's error apparent on the face of the record of that order? What is the counsel saying?
Sufficient grounds it will not cover.
No, that is ejusdem generis to the main thing. That is ejusdem generis. That is what the board will, commission will show is
Very good. Then the subsequent discovery of facts.
subsequent discovery of facts. Very good.
This is subsequent to that.
Very good.
Subsequent to the disposal of the appeal, sir.
Yes, maybe. I do not know what this is the main thing, Lordship. It's not known to your Lordship when the fact
This
was
thing is traveling
discovered.
from the very beginning,
Yes, but when the fact
and I
was
have traveled,
discovered.
Mr. Dhar, on a
Yes, ask that question to commission. When the fact was discovered. When this mistake was discovered.
The mistake was discovered. The mistake was discovered
Hmm.
at least prior to passing of this order. That is on.
Single bench order?
No, sir. That is while immediately prior to or at the time of filing CAN 20 of 2020. Take your seat, sir. I've heard you. Don't interrupt.
Yes. See, right. They're discovered on what basis that the inference is being made.
Let me have an audacity to travel, Mr. Mitro.
My lord. Sorry,
Let
good
me
lord.
have an audacity to travel, Mr. Mitro.
No.
With
my
my-
lord, I
With
am,
my rather what will see,
I
I
am
with my dull brain.
I am a counsel, your lord. Now, where from the deduction is being made? Nobody's case is that. That is discovery of fact. Can you take order 47 rule 1?
Yes, sir.
Discovery of subsequent event
Hmm.
will create an error in the order of court. Order is event which has not
Discovery or who from the discovery of new or an
Yes.
important matter of evidence
kindly
which after exercise of due
which has
diligence
taken
was
place.
not within his diligence with his knowledge
Right.
or could not be
Correct.
produced by him at the time when the decree was passed or order made or an account of some mistake or error.
Yes.
I will not go that.
Yes.
Or for any other sufficient reason.
Yes.
But
Yes.
on the first ground, sir.
Pass ground. Yeah, excellent. May I read only once more?
Yes, sir.
You know, can an order be said to be erroneous on the basis of event or facts which are not before the court at that time? It says the facts which were there in existence at the time order was passed, but subsequently discovered by a party, and which he could not have discovered earlier by due diligence. Now read the 47(1). An order of court will be condemned as erroneous because subsequent something happened. Is that we have to argue this point? Can he order 47 rule 1? See, that's what said. Fact was there, event was there, but the reason was there. But when the order was being passed by the court, but that could not be discovered by the parties appearing.
Sir, I'm again traveling.
Okay.
Please excuse me, sir. Try to visualize the situation.
Yes.
Try to visualize the situation. Please pardon me for my audacity, sir.
Lordship.
Sir, try to visualize the situation. Before this single bench, Malakar approached for non-publication of the result. Single bench, the coordinate bench passed a direction to prepare panel, call for blah 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 that we have placed. If he is found to be successful. Challenge was made by the commission before the division bench, and at the time of hearing, the commission practically abandoned the ground of appeal,
Yes.
paid for extension of time. So, on the day of disposal of the appeal before the division bench, the alleged deprivation of 73,000 was not known to them. The commission again came up before the division bench on account of their infrastructural lacuna, maybe on account of inadequacy of logistic. They could not publish the result. Extension was granted. Now they have come with a different stand that on account of technical mistake as quoted by quote unquote by Mr. Dhor allow us to allow for grant further time so that we can take re-examination. The division bench unable to comprehend the stand of the commission for holding further examination. However, on a humanitarian ground, the matter, the time was further extended for certain period, 6 months or so. So my point is at that my point is that at the time of filing that the commission was aware of their alleged technical flaws. Yes, sir.
Yes.
So those flaws, those technical flaws comes within the periphery of discovery of new and important matter of evidence. Had it been known to the commission earlier, at the time of hearing, the appellant commission before the division bench must have raised that grounds in the appeal. That has not been taken. So even then you are saying that it is not a fit case for ground of review.
Okay. Now all my learned men who are opposing this, they say that this technical flaw or mistake was discovered after disposal of the appeal. They're all saying that very vehemently, paragraph 3 or something, you said that. They have discovered this mistake after disposal of the appeal.
Naturally.
Now read order 47. Whether that could be brought in to notice of the court while disposing of the appeal.
No, it cannot. That is why I am talking about the review, sir.
Can they come to me, section order 47, rule 1? Submitting a first part. And
yes,
from discovery of a new and important matter or evidence, which after exercise of due diligence was not within his knowledge and could not be produced by him at the time of the decree was passed. The fact was not known to them.
That exactly that I'm on. So that is a ground of review.
Can review whether Milord.
We are reading order 47 rule 1. No, it's a review.
No. Yes, I'm reading that. Provided that ground that produced exercise duty was not within his knowledge and could not be produced by him at the time when the decree was passed or was order made or on account of some mistake or etc. on the page. Whether after which important matter or evidence, which after exercise of due diligence was not within the knowledge and could not be produced by him at a degree. Whether this mistake was not discovered by them.
Sir, exactly. I am with you, sir. I am with you.
Yeah.
Had it been within the knowledge of commission at the time of hearing of the appeal, they could have taken it. They could have taken it even by amendment of the memorandum of appeal. It was subsequently noticed by them. It was subsequently discovered by them, which is why they have preferred the CAN 20. They remain unsuccessful. Even then, they have not come forward with an order 47.
Yes, they have not chosen to apply for review of the order of the appeal court or single bench, which took place in the year 2022 matter over. Now, does it mean review is not been done? So what follows from that? Assuming review could have been made, this exercise of due diligence, was this mistake discovered or could be discovered within the time when the appeal was heard? The commission was defunct for a period of 5 years. According to COVID, affidavit, COVID was 2 years away. 2 years. So what is the case made out by any party here? But that is mistake which are discovered by the board could have been discovered or could have been discovered by exercise due diligence in 2018. That case has to be made out. If Order 47 Rule 1 applies, then similar the language is which after this exercise of which after exercise of due diligence was not within his knowledge or could not be produced by him at the time. I'm saying so. Was the exercise that was going on from 2015? The commission is defunct up to 2020. These are all question of fact. These are all question of fact. Question is when it was discovered, and question is whether that could have been discovered earlier.
একটু এদিকে কাউকে ডাকুন, এই দরজাটা খুলে গেছে, একটু বন্ধ করতে পারো?
Two things appear here. Whether this exercise of due diligence would have been discovered in 2018. Which led to a discovery of this mistake when the resolution was passed in 2000, the date has been now given, to correct the mistake.
Very good, sir.
It's a question of fact. Now, next, kindly come to the question, review not made. So what? What follows from that? Order remains binding without any modification by the court. Lordship is considering whether the extending court has modified the order. Exactly, that's the question they are now raising. Reading the order as it is, of single bench and division bench, there is no dicta that don't hold any other examination if any situation arises.
Very good, sir. Come to the next point.
Now, the next point is, if the court implies or draws the implication from the order of our division bench or single bench, that will be rendering the order illegal. Because the party who have been 73,000 examinees who had right to be called for written examination were not parties before in that proceedings. They are not made parties to that proceedings. And in that proceedings, court could not have passed any order affecting them. Same thing applies in this proceeding also. The petition which they have now made without impleading the affected parties is totally illegal and it is to be dismissed in limine. Court, it is not in Hamilton settled law that no court has the jurisdiction to pass order affecting non-parties to whom notice has been given. This will not apply to the order of the single judge and division bench if such implication is raised. And Mr. Thor rightly said, deductions can be made, which is lawful deduction. It would not be lawful to deduce that our division bench or single bench would have passed the order affecting those successful candidates in the skin test and asking them or depriving them of the right to appear in written test. Same thing applies in the current proceedings. None of the parties, none of the successful candidates have been made parties here in these proceedings. No notice has been given to them. No step for making a representative action has been taken. This order is totally pushing bad. My humble submission, my lord, please to dismiss the writ applications, all the writ applications on this ground alone. Lord, may I? There are several judgments. Lord, I am to cut short the matter. I'm relying on 2014, volume 16, Supreme Court cases, page 187. There is no paragraph, my lord. Paragraph there, I read the judgment. You could have to copy the judgment. Yes, sir. Huh? Indian आगे चाहती है ना कि very important. Because I thought you should avoid citing so many judgments which are referred to here. Yes, must be aware of this.
Yes.
কপি আনতে পারবে
দেখুন
নিয়ে এসো তাহলে।
আমার কাছে থাকতে পারে
হ্যাঁ?
আমার কাছে মনে হয় আছে
দেখো দেখো দাও
রঞ্জন কুমার
নামটা
রঞ্জন কুমার
রঞ্জন কুমার
পেয়েছো
রঞ্জন কুমার
আনো আনো তাহলে এক্ষুনি let us go to another topic with that
Give me a second, sir. Give me a second.
is an application represent read
Lordship
application
is using the iPad, so I can airdrop. I mean, I can use a Bluetooth directly. It can go there without anything.
this is not fair on court. This is not fair on court.
Give me a second.
Should I send?
No, not required, sir.
Not
If I require, I do.
And that is gracious enough to read from that. And got it, Miller.
Give me a second, sir.
Exactly, facts are similar. The writ petition, all the three writ petitions have to be dismissed on this judgment. Some parties were made parties in this case. Some of them.
This is not right.
near. Hmm? Thank you. Very kind.
Yes.
In this case, below, some of the successful candidates were impleaded.
Ranjan Kumar and others, na?
Ranjan Kumar. Well, may I now place it, Miller? Then my humble request, Miller, use this, but don't use it too often. It affects your eye. It affects eyes. But do it.
It has become now an integral part of our life. What can be done, sir?
And Miller, it has.
Space is real problem nowadays.
Yes. And Miller, it has.
And maintenance of libraries, sir.
Yes. And Miller,
Since my family belongs to legal fraternity, and sir, and since my mother is a chairman, library.
Yes.
Nowadays,
And when I find my juniors bad, Mr. Thor and others, all have only one.
We don't have other option. No option. No option, sir. No option.
But it is when a strain on eyes. Don't do it. But I am grateful to your lordship for also taking the trouble. It was our duty to give a hard copy. That's very gracious of you, lordship. May I read this judgment now, my lord? Should I? In these appeals, Assay issued a judgment and order dated 1920, passed by the High Court at Patna, in a batch of letters patent appeals, in our case, same thing, whereby division bench has concurred with opinion expressed by the learned single judge, wherein he had quashed the appointment of number of appointees in respect of post, namely these four. Same prayer they are making here. Quash the appointments. Same prayer. On the ground that the procedure adopted for selection was vitiated, as the candidates were selected only by interview without holding any written test, though the past practice was to conduct an examination and thereafter hold interview for selection, that the interview was held in a hurried manner and that the post being technical, selection procedure was bad. Same thing, the procedure bad here. Same ground. We need not state the facts in detail. Suffice it to say that in pursuance of an advertisement issued by the department concerned of the state government, 182 persons were appointed, in our case 297 persons, on the post of MLT. And each petitioner who participated in the interview could not be selected, same thing here also, as they obtained lesser marks than the successful candidates. Their failure necessitated them to knock at the door of the High Court, and the learned single judge, as has been stated here before, accepting the grounds put forward, quashed the selections. The learned counsel for the appellant have raised two principal contentions. First, most of the appellants herein were not impleaded as respondents before the High Court, and without taking note of the said aspect, the High Court has invalidated the selection and nullified their appointments, which is violative of the principle of natural justice. The second, all the private respondents who were writ petitioners before the High Court, having participated in the interview, which was the procedure adopted, could not have challenged the said process in the court of law because of the failure for them. Both these grounds are taken by the commission in their affidavit. I'll place a paragraph. Grounds have been may not all, but grounds taken. On a perusal of the order impugned, we find only 40% were made respondents. In our case, none. And hardly a few appointees filed application for intervention. It is well settled in law that no adverse order can be passed against persons who were not made parties to the litigation. And that is the implication they're asking your lordship to draw from the division bench order. The division bench intended to adversely affect the successful candidates from participating in written test. That is the inference. That will be I may not submit, I will submit that no deduction should be made of a court order which will render the court order unlawful, unlawful. This is what they are trying to do. In this context, we refer to the authority in Probodh Padmama state of UP. That is a bench judgment, wherein three-judge bench was dealing with the constitutional validity of two Uttar Pradesh ordinances, which had been struck down by the division bench of the Allahabad High Court on the ground that the provisions therein were violative of Article 14 and 16(1) of Constitution of India. In that context, a question arose whether the termination of services of the appellants and the petitioners therein as secondary school, secondary school teachers, and the intermediate college lecturers following upon the High Court judgment was valid without making the said appointees as parties. Learned judges observed that the writ petition filed by the Sangh suffered from two serious, though not incurable, defects. The core defect was that of non-joinder of necessary parties. For respondents to the Sangh's petition were the state of Uttar Pradesh and its officers concerned, and those who were vitally concerned, namely reserve pool teachers, were not made parties, not even by joining some of them in a representative capacity, not even by joining some of them by representative capacity. Considering that their number was too large for all of them to be joined individually. The same has not been done here. Thereafter, the court ruled, matter therefore came to be decided in their absence. A High Court ought not to decide the writ petition under Article 226 of the Constitution without the persons who would be vitally affected by its judgment being before it as respondents, but at least by some of them being before it as respondents in a representative capacity, if their number is too large. Therefore, Allahabad High Court ought not to have proceeded to hear and dispose of the Sangh's petition without insisting upon reserve pool teachers being made respondents to the writ petition, or at least some of them being made respondents in a representative capacity. And had the petitioners refused to do so, ought to have dismissed the petition upon non-joint necessary parties. It is not possible in respect of the main list now. Now, paragraph 5 is summary of law. In this case at hand, neither was any rule nor any regulation challenge. Same thing here. In fact, we have been apprised that all the time, selection and appointment, there is no rule or regulation. It is wrong. In our case, there is. A procedure used to be adopted by the administrative instruction. That apart, it was not a large body of appointees but only 182 per appointment. Quite apart from that, persons who were impleaded were not treated to be in representative capacity in the regard parliament. So 40% were impleaded, 40 of them successful candidates. Even then, since they are not impleaded in representative capacity, it was held to be bad. In our case, number two. Then these judgments are, so many judgments have been referred to for the same proposition. I'm citing judgment for avoiding citing so many judgments. In first judgment referred to is Indu Shekhar Singh. There is another aspect of the matter.
Rasmi Mishra.
Appellant herein were not joined as parties in the writ petition filed by the respondent. In their absence, High Court could not have determined the question of interest. Was again below. In the proceeding before the Justice Pratik Prakash Banerjee and Justice Division Bench, the writ petition number, none of those appointees or successful candidates, if they are there or not, or prospective one, they're made parties. Only commission. An order is supposed to be, if is now held that by that order, not directly but impliedly, High Court had directed that no written test will be held, even for the successful candidates, that will be violation of natural justice and void. And my humble submission to your lordship and to my learned friends also, that don't impute such inclination to pass illegal order on the part of any High Court judge, of our High Court judge at least. It is not permitted to think that court will pass an adverse order against parties without making them notice, and that by implication you imply that. That is not so. If I may know, this is causing counter. Next, Rashmi Mishra, after referring to another judgment of Supreme Court, huge number of judgments have been quoted here. In West Bengal case, paragraph 8, this court approved a view exhibit tribunal which had opined that for absence of selected and appointed candidates and without affording an opportunity of hearing to them, the election could not be set aside. Could not be set aside. In West Bengal case, it absolutely. Paragraph 8. In Public Service Commission, such and such, paragraph 2212 SCC, this court, while dealing with the concept of necessary parties and the effect of non-implementation of such party in the matter when the selection process is assailed, observed thus. Udit Narayan Singh's case, wherein the court has explained the distinction between necessary party and proper party and pro forma party, and further held that if a person who is likely to suffer from the order of the court and has not been impleaded as a party has a right to ignore the said order, as it has been passed in violation of principle of natural justice. More so, proviso to Order 1, Rule 9 of the Code, hereinafter Code, provide that non-joinder of necessary party be fatal. Undoubtedly, provision of the Code are not applicable in its jurisdiction. Code not applicable by virtue of provision section 1% of the Code. But the principle enshrined therein are applicable. Then judgment of Supreme Court referred. The next judgment is Jadhav versus State of UP. No order can be passed behind the back of a person adversely affecting him, and such an order, if passed, is liable to be ignored, being not binding on such party, as the same has been passed in violation of natural justice. That unfortunately, my lord, even before your lordship, when the matter was moved for interim order, it was not pointed out to your lordship that this order cannot be passed because of the affected parties by order to be affected by the order which will affect the parties are not at all implemented. Had it been brought to my notice, I'm sure lordship would not have passed any order. That order in violation of natural justice. That don't allow the successful candidates to appear in the second written trial. No doubt lordship would have. So court knows the law, but court has to be alerted on some points of law at the relevant time. Otherwise, it's not possible that the busy schedule of a judge to appropriately remember it. Court has to be apprised. That's our job. That's the council's job. That these are the possible position of law. And I have no doubt, with humble respect to your lordship, that you would not have passed that interim order had your lordship been told that the parties who affected are not implemented. The order, when invited from lordship, violated natural justice, which according to Supreme Court is void order. That order, I have no doubt also will recall that order and vacate it. Then Lord Vijaya Kumar, Union of India, etc. And as I highlighted, no dispute of factum of severity. Lordship has
Actually, 3-4 মিনিটের মধ্যে চলে আসবে।
that are quoted here is come up to paragraph 13. Can you read paragraph 13? In view of the aforesaid enunciation of law, we are disposed to think that in such a case, when all the appointees were not impleaded, the writ petition was defective and hence no relief could have been granted to the writ petitioners. But this is judgment citing not only for this dismissal of this writ petition, but also to persuade the court not to draw the inference or implication that the division bench held that if the successful candidates are not to be allowed to participate in testing because they are not parties. And if the division bench are held so, my lord, I don't, is it not arbiter or anything? I'm saying there is no dictum, no question of arbiter here. Then, that will be a void order. That will be a void order. To that extent, but by first submission, division have not held so. Said after holding written conduct. Nameless thing is the second part of his judgment. Second part of the judgment, paragraph 14. Another ground for dismissal of the writ petition. Paragraph 14 at page 192. Of this chapter. 14. The next submission, which has been presented before us, is that when the respondent had appeared in the interview, knowing fully well the process, they could not have resigned later on or taken a somersault saying the procedure as adopted by the department was vitiated. In this connection, it is apt to refer to the principle stated in Om Prakash Shukla's case. In the said case, a three-judge bench, taking note of the fact that the petitioner in the writ petition had appeared for the examination without protest and filed petition only after he realized that he would not succeed in the examination, held that writ petition should not have been granted anywhere. I'll show Miller from their own case. Writ petition knew they participated. Is Mr. Bishop Vishnu he had participated in the second written test procedure. He has participated. And when his name did not appear in the aptitude test, then he applied. Unsuccessful candidates can, after taking the chance, cannot appear. In this context, we may quote passage from Madan Lal. It is now well settled if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn round and subsequently contend the process of interview was unfair or as a selection committee was not properly considered. In Om Prakash Shukla's case, it has been clearly laid down by bench of three learned judge that the court that when the petitioner appeared at the examination without protest, and when he found that he could not be succeed in examination, he filed a petition challenging a said examination. In another Chandra Prakash Tiwari's case, there is no doubt that while question of any estoppel by conduct would not arise in the contextual fact, but the law seems to be well settled that in the event of a candidate appears to be interviewed or participate therein only because the result of interview is not eligible to him, he cannot turn down. Then Union of India, that both and petition was dismissed. Now, in this connection, the question raised, questions occurred in course of discussion. See the affidavit, comprehensive affidavit of the commission. Paragraph, page 21. Sorry, paragraph, page 20, Lordship, can you see? That is the commission's view. The court has not addressed. Paragraph, page 20, after the quotation, but second of this 13 June order has been quoted. Can you see middle of that? Page number 20 below. 20. Middle, just before the quotation. Let's go to the quotation. The Honorable Division Bench considered can number 20 of 24 was pleased to pass an order 13 June and the following observation. Taking a pragmatic view of the matter, we extend the time for a period of 3 months from the date of completion strictly in terms of order of single bench assembly. By such order, Honorable High Court has not restrained the recruiting authority from holding the written examination of 73,000 candidates who were successful in the preliminary examination held on recommendation, but couldn't be allowed to sit for the written examination held on, etc., due to the technical error of the Commission in earlier evaluation of mobile sheet. Subsequently, we published a notice of the holding an examination who were successful. Now, then the next page is important. When this mistake dawned upon, on 30th July 2024, a recruiting authority published a notice, can you mark the date, 30th July, to complete the first Group D examination within 10 September 2024. Thereafter, by a notice dated 4th August 24, Commission published a list of 24,577 candidates who appeared in written test of first SLST held on 29/5/2021, and on 5th of August published a list of 73,978 candidates who were successful in the preliminary screening examination held on 20th November, but could not get the opportunity to appear in the written examination due to technical fault and error in evaluating the OMR sheets of the preliminary screening exam. Admittedly, no fresh candidate has been called for or allowed to participate in the written examination, except the applicants who appeared in the preliminary screening test examination held on 28/11/2010 and were eligible to appear in the subsequent written examination. Subsequently, a notice was published on 11th August 2024 for holding written examination on 1st September 2024. It was issued. They all knew notice was issued. Written second examination. Why not come to court then? Allow the examination to be held. See, my lord. The next written examination of 73,000 left out candidates held on 1st September 2024. Commission has not violated the observation made in paragraph 13 and 17 of the judgment and order, as no further written examination of those 24,577 candidates who had participated in examination held on 29 November was conducted. This is the view taken. No further examination of those 24,000 candidates who had participated in the written examination held on 29/5/11 was conducted. In fact, the Commission on 1st September 2024 conducted the written examination of those 7,578 left out candidates who could not get the opportunity to appear in the written examination held on 29/5/2011 due to technical fault and error in evaluating the OMR sheets of preliminary screening examination. So the written examination held on 1st September 24 is neither a further written examination of those 24,000 candidates who had participated in written examination held on 20, nor any written examination of any new candidate. Result of both written examination held on 29/5/11 and the candidate 22 was published jointly by taking all candidates of both written examination together on etc. and a list of 3,233 qualified candidates were selected for personality test as per merit, and the set was published along with a list of final vacancy contrary to it. So it was published that they knew that their name, they had not been invited for aptitude test. So they had not been successful, they knew. for the post of Group D, etc. The personality tests were held on 18th September 2024 to 30th September. Subsequently, final merit list by notice dated 4th October 2024 and the date of counseling was by notice dated 5th October 2024 were published. The Honorable Division Bench, in terms of a judgment and order dated 13th June 2024, has not restrained the recruiting authorities from holding the written examination of 7978 candidates. There were no irregularities. And my only addition in law is, please don't infer that, because that will make the order of division bench extending court unlawful, void, and violative of natural justice. Therefore, my lord, you cannot, court should not deduce or imply such order as would render the order unlawful. Photocopy application, etc., all annexed. This is the fact now they have said. So when the mistake was discovered, it was 24. There is nowhere it is stated, and there is no ground to think that the mistake was discovered in 2018. The case was heard. And but nobody said, then see the case back. Has anybody alleged? If I reply to this, I don't have copy, don't reply. Kindly see, have anybody alleged that this mistake could have been discovered by the Commission by exercise of due diligence in 2018? Then question of review arises. It's a question of fact. Kindly remember, my lord, 2015, 2020, the Commission was defunct. These arguments on facts cannot be made which are not on record and which are not plausible from the records. I agree, my lord. My lord has said, my lord, indeed. But if a fact which could have been discovered by the board, by a party, by exercise of due diligence, when the order was passed, but could not be done, because you then arises for review. But then Lordship can consider that if I has not accepted the review, what does it mean? If I have failed file appeal, then I'm Commission accepting the order of a single bench. That's the highest. That accepting the order of single bench, that's all. Commission has always accepted the order of single bench, rightly or wrongly according. And division was directed from the order. So how is relevant to think that review was not made? Review was required to be made if the board thought that the order of Justice Patrick Prakash Banerjee, my lord, did restrain board, the commission, from holding the written test for successful 73,000 candidates. What I expressed the affidavit, board can never consider that to be so. Even now, that is not a board case. So why the board should apply for review? When board did not think. So again, board
No, it's all right.
Commission.
Board commissions,
Why the commission?
recruiting authority.
Commission, when did not think that the single bench had restrained them from considering 73,000 successful candidates to be allowed to be read. Then on what ground board will apply for review? For review, my lord, now comes the question of why board could not apply for review. I'm now humbly trying to answer my lord's query. And now I'm humbly trying to answer that. Board could not apply for review because it was never the case of board that a single bench order suffers from any error apparent on the face of the record. That single bench order, a division may confirm, had restrained that board from holding the written test for the successful candidates. For review application made, board has first said that by this order, what is the error? The commission has been restrained from holding written tests for so many candidates. Then only board could apply for review. After the application of review for correcting error on record, a mistake on record. But board is not saying that was a mistake. Board is saying, no such order was ever passed. It was not a board case, there is an obiter dicta. And obiter dicta cannot be about a question of fact. Board case says, no, that was not the order passed by the board, by the commission. And if an argument made, kindly don't listen to it. Well, affidavit, that is the case of the board. Then how could they apply for review? My humble submission is, board could not have applied for review. Because according to board, there is no error, no such error on the part of the High Court restraining successful candidates from appearing in written tests or offering it.
Yes, sir. Any other
Hello.
point?
Well, let's say res judicata. Question res judicata. Court, this order of division bench is a only what was the res judicata there. Is in for judicata what? Res for adjudication was whether ground existed.
No. Res judicata point was never raised by the writ petitioner.
That
It was raised by the court, and
Oh,
subsequently it has been noticed on perusal of the relevant
I
section
did
10
not address it.
that it was not.
No.
It must be between the same parties
I
or litigating under the same title.
no, I'm
So
no.
be
I'm not-
rest assured that it will not be reflected in my
Not
judgment.
that. Not, my main question is this was not for adjudication.
No. It was
Extension-
never raised. It was raised by the court in course of argument of Mr. Thor, and subsequently I noticed that it is not applicable because it is neither in between the parties nor litigating under the same title. So you need not argue, Mr.
Permitting
Vic.
that.
Don't waste your time and energy over that.
Now, board has filed the examination written papers, question papers, and have submitted. The standard of second examination remains same. That's submission.
Level playing field.
That they have submitted. I have not seen the exam paper. I am not a party to these proceedings. I am not, but that's the observation that I accept. I will not dispute with that. Now, my lord, kindly, what is the next point left? That next point is not the division bench order of the 13th June could be read as the order of a court
Yes.
Now, my lord, kindly see page 114 of the affidavit. What are the marks? 50 marks was the
Affidavit of
board. Sorry,
composite affidavit. Page number, sir?
114. Just to apprise your lordship that the question marking was this. Preliminary screening examination maximum 30 marks out of 50. Written examination 15 marks only. And personality test 5 marks. And see the breakup of this 15 marks. Most marking on the preliminary screening examination, group D stuff. And got to get the breakup of 15 marks at page 119. Even the 15 marks at last paragraph of page 119. For the post of group D staff heading. Written examination. Question in the written examination will be 1. General English 8 marks. Arithmetic 7 of class 8 standard. The test will be 0-1 hours duration. 8 and 7. Arithmetics 7 and English 8. Group D staff. Now, having that, I only point left with me to deal with. Let's get. No level playing ground argument. It is bad. No level. What is meant by no level playing ground? You have relied upon a judgment of the Honorable Supreme Court. No level playing ground means that all successful candidates at the preliminary examination screening are allowed to sit in written examination. Level playing ground would have been affected if out of, let us say, 73 plus 24,000 successful candidates in the screening test, only 24,000 is allowed to have seat in the written test. Then there will be discrimination and no level playing ground. No level playing ground is based on the question of discrimination. Has been discrimination. Now, my lord, there would have been discrimination and no level playing ground had out of 73 plus 24, let us say 1 lakh successful candidates, only 24,000 was allowed to sit in written text and balance 70,000 was not allowed to sit in written text. Therefore, it is allowing written test to the remaining successful candidates is creating the level playing ground. Next point is, and what is the rule of the game? Rule of this game is that there can be separate tests for the candidates. The preliminary screening test, which held the highest mark of 30, was held in 3 zones. And 3 zones were given 3 different questions. That is the case. And that is an affidavit also of the commission. So, rule of the game in this game was, yes, the different written question papers could be framed for the same group, for entire examining group. And that is how this game started. That lordship will find affidavit paragraph to do it or no.
Mr. Mitro, the argument of the learned advocate for the writ petitioners
Yes, my lord.
that in order to achieve the correct level playing field, there must be, you must be backed by rules and regulations.
Yes, correct.
So far, my recollection.
Absolutely true.
And for holding examinations on different question papers on different shifts, you are also required to be backed by rules and regulations.
Yes. And other.
Sir.
Oh, bless Lord.
And they have referred the case of Aditi, where the Honorable Apex Court,
Supreme Court.
while the Honorable Apex Court
Yes, Mr.
expressly held that holding examination in two seats would invariably enable arbitrariness and would not entail at par evaluation.
Yes, I'm aware of that.
Holding examination in two seats would invariably enable arbitrariness and would not entail at par evaluation.
No, my Lord, absolutely not. I'm grateful to my Lord. Coming to that. So there's questions. One by one, if I may deal it one by one. First, my Lord, there is no.
Now, in this matter, everyone is having an excellent learning experience. Everyone. Yes, sir.
Now, my Lord, first question, the regulations. Absolutely.
That was my question.
Yes. Yeah. First question, rules and regulations do not prohibit holding of multiple written tests.
That has been argued by Mr.
Argument Mr. Todd has shown you a lot.
Yeah, on the basis of the proposition of general causes act.
General causes. Singular includes plural. Yes, I to judgment. General causes act, I have got the sections noted. I can give the section.
Settled question.
Therefore, there is no prohibition under that. Knowing the regulations, they will participate in the preliminary screening examination.
Though that is undisputed, sir. That is undisputed.
Yes. And they knew that different question papers for three different zones. Then they did not think it was violative of rules or regulation. They started with this rule of the game that there may be different tests for different categories of persons. So there is no change of rule of game here.
Sir,
It's a second question.
I must be very frank, honest, and fair that on perusal of the question papers for the written examination as held on 29/5/2011 and as held on 1/9/2024, I find you people say the courts are experts of expert. Level playing field are maintained. That I've noted.
Okay.
So be rest assured that
Yes.
that is my finding. It's not prima facie finding, it's an inconclusive finding.
Nominal.
Question is only whether you are backed by any rules or not.
It not be.
You are backed by any rules or not.
That is backed by.
And in that context, I have stated to Mr. Dhar, so if my recollection goes rightly, that everything cannot be stated in acts, everything cannot be stated in rules, but every action of the commission must be backed by at least by a resolution of the committee prior to holding the examination. What I troubled Mr. Thor, that prior to holding the written examination dated 29/5/2011, had the commission taken a decision that they will take written examination in 2 or 3 phases. That question I have asked Mr. Thor.
Mr. Thor, may I also try to answer the question? May I only, by Lord's kind permission, say expression whether backed by the rules? I like to say whether prohibited by the rules. Backed by the rules means it must be express prohibition, express provision that written test can be held twice. I am only trying to modify with minor kind, but for minor kind acceptance. The test would be whether it's prohibited by the rules.
Sir, absence of no can be absence of absence of no. Absence of no can be termed as can be interpreted as an yes.
Yes.
Can the
Yes.
rule of game be
Yes.
can the
Yes.
rule of game can the rule of examination can be altered when the game starts or examination recruitment process starts?
Cannot be altered. And it has not been altered.
Cannot be.
Has not been altered in this case.
Cannot be.
Yes, but agree, Milord. I told respectfully agree. Now, Milord, may
Had it been such a case, that noticing their own defect, the commission have taken a decision that they will cancel the earlier examination and they will hold the entire written examination afresh, it could have been otherwise. Question is, again on level playing field has been maintained. Question is whether holding of second phase of examination, even maintaining a level playing field, is at all permissible in the perspective of the acts, rules, and the action of the commission prior to selecting the mode of examination.
no problem. No, this is where the crux of the
I believe I am not.
no, no,
My question is not irrelevant.
no question totally relevant and quite lucid, if I may humbly say. Now I am in a position to make my humble submission on that. If they're really silent on the subject, then what will happen? Lordship, I have cited a judgment already. Then administrative discretion come into play. The judgment, you can take it, the judgment that was cited today. If the rule is silent on a point, then administrative discretion holds the field. And the administrative body has the discretion to do this, fill up the vacuum. That's why I humbly submitted. Please don't say whether backed by the rules, but see whether it's prohibited by the rules. Then it is illegal. It's contrary to rules.
So your contention, Mr. Mitro, that holding of written examination in two shifts were not prohibited by the rules.
By the
That is your contention. Very good. I understand.
It is
Thank you.
then. This Penal Causes Act, etc. But there is no provision clause. Next, Milord, what is the rule of the game in the absence of that? In the absence of it, the commission in this case have set up the rule that in this selection process, there will be different sets of question papers for different candidates. And the screening test, which had highest mark, that's why it's only 30 marks out of 50. The screening test was held by submitting 3 different sets of question papers.
Sir, I will not go to that point, sir.
Why not?
I will not go to that point because that was not question.
That
was not question.
That applies to
That is not the subject matter of the news.
Correct. Yes, this
I will adopt your contention that they have acquiesced to that. They have the petitioner has acquiesced to that. They will not. I will not allow them to.
That's the
question is holding up. You have stated that holding of written examination in two shifts were not prohibited by the rules. That I understand.
Basically, there is no change of rule of game. Customer admit that. Will accept that. Because in
That will, I'll accept or not, that will be reflected in my judgment. What I've accepted, that I've disclosed.
but my lord, in course of
What I have accepted, that I have disclosed, and what I will decide to accept, that will be reflected in my judgment.
that it is also may with politeness I would say, court do not keep the points up their sleeves. Court do not keep the
No,
point
no,
up
I'm
their
to
sleeves.
come to a logical
No, no,
conclusion of
but
the same
let us
to
forget-
the best of my ability, of
No,
course,
no,
sir.
not Kelly. Now, look, my submission is this, that in this case, board has rightly wrongly set up a rule of game that there will be different test papers, question papers, for different zones of candidates. So, we'll not time findings, different question papers, different sets of papers is a rule of game in this. And knowing that they have participated in that. Therefore, if there could be the different sets of written papers, written tests, at the for the highest mark, 30 examination, then why not of 15 marks? Written test. Why they can say so? Because that then nobody has pointed out, rightly made out, there's a acquiesced in that. Acquiesced in they accepted the rule of game, right or wrong.
But here they have not acquiesced.
Therefore, they cannot later on say.
But here they have not acquiesced.
This is
In
the
the
beginning.
written examination, they have not acquiesced.
The game started, the rule was that there can be different written tests. That was the rule set for the game, for the referee. And that rule has not been changed. That rule has not been changed. True? And that rule they have not objected to. Thirdly, we just now Supreme Court judgment. But hello, there is no change in the rule of game in this case.
Mr. Mitra, how long you will continue?
I'll try to finish today, Miller.
Today, very good.
I might not give me extra 5 minutes.
Yes.
That's not my client.
Take your time.
Really poor clients. Last is the judgment of Supreme Court. Before reading a judgment, I shall submit from this judgment appear that it has been the practice of various institutions to have different written tests. And that was never said to be bad or wrong. Question is whether written test, second written test, in the facts of the particular case will be bad or good or bad. There is no rule of law.
Sorry.
There is no rule of law saying the written test cannot be comprised of different question papers for different zones. Cannot. There is no rule of law. There is no statute saying so. No statute saying so. And there is no rule of law saying so. On the other hand, now see the Supreme Court judgment will not only it's the interim order. Anyway, this judgment Mr. Bishuru has relied on that. Oditi and others.
That I have referred now. Just
Yes.
WP civil number 456 of 2025.
This is an STC
WP
online.
civil number, yes. ये judgment फाइलটা দেখি ভাই রিপোর্টের ডিসিশনের ফাইল just a minute sir. Yes, sir.
First, my lord, as I'm borrowing from my lord's observation, my lord, that there's been no violation of level playing grounds.
Yes.
Lordship, no violation of level playing grounds, and the question papers are of same standard. This, having regard to these two facts, can it be said to be wrong by the court of which court, who is not a court of appeal?
Hmm.
Paragraph 8 will not come. No, sorry, my lord. The ground, what the ground was that is it. See the first paragraph, my lord. Paragraph 3. One is that holding of national eligibility examination in 2 shifts would give rise to arbitrariness. Why? As it does not extend.
Sir, straight away come to paragraph 10.
No, paragraph 3, can you see?
Paragraph
3.
3. Oh, I'm sorry. Yes.
One is that holding of national eligibility, etc., in 2 shifts would give rise to arbitrariness only, as it does not extend a level playing ground. Level playing ground, my lord already observed it, to all the candidates. And as much as 2 question papers can never be of the same standard. That is, for example, question also found a question paper same standard. Both the grounds are fulfilled here. So both the ground of level playing ground is not disrupted, and question paper of same standard. This is the reasoning why it cannot be done. And the process of normalization, it is last year, NET, PT examination held in 2 shifts, and the process of normalization was adopted in the scenario. So it was last year, it was held by this institution in 2 shifts, and that was not held to be bad or anything. These are the facts. Now, let us kindly see why it is wrong here. Paragraph 8. Why Supreme Court, the interim order says it is, I know nothing. The contention, this contention deserves to be rejected, as there is still enough time for the examining body to identify sufficient number of secure centers so as to hold the examination in 1 shift. By the time, this mistake, 2024, and the High Court order is that you must do it within a particular time. Then, in this case, why is there any time to hold the 2 examinations? There's a whole thing. That is the reason.
Sir, I beg to differ, sir. So far as the Aditi case is concerned, it deals with the level playing field and
Same standard.
process of normalization.
Hmm.
So far as the level playing field, I'm okay.
And
It is
same
okay.
set of,
And what is the
question
process of normalization? That must be backed by the rules, regulations.
paper. No.
Must be backed by the at least by resolution taken by the how the process of normalization will be done.
Normalization is done.
How?
Both
Simply
the shift-
holding an examination in second shift.
No. Second shift, all the then marks have been considered together. And thereafter the list has been prepared. Therefore, I've read out that paragraph to your lordship. It was normalized. Paragraph, yes. Paragraph page 22. Results of both written examination held on 29/5/11 and 1st September 24 was published jointly by taking all the candidates in both the written examinations together on 99 and list of them paper. That was done.
Very good.
And then, my lord, in that case, a ground for that. See, my lord, why this is so? Paragraph 9. Paragraph 9. We find that total candidates who have applied this year was 2,42,760. Examination will be held all over the country and not in one state. We are not ready to accept that the entire country, considering the technical advancement we have achieved, Extraordinary examination body cannot find sufficient number of centers to hold examination. And they're taking fees of 3,500, 2,500, paragraph 9. This you know, তিনটে সেডিপেন্ট পরীক্ষা ছিল তুমি বলেছো তো তুমি বলেছো এটা বলছি ছিল এই তিনটে কমিশন বললুম তো
তিনিও ছিল নট অনলি স্কিম তিনিও ছিল
তিনিই থাকবে তো এটা বলে দাও তুমি আরেকবার বুঝলে কমিশন বলে দাও আরেকবার Now, the next thing is, in this judgment, I'm talking of this judgment. This judgment, this order was passed, interim order was passed, before the different tests were being held, not after. Not after participation in that test and then coming to court. This injunction was placed and no, it should not be done. There's a difference between a faith allowing a thing to be done and then come to court, and it's coming to court before that. That's not last point, paragraph 10. I'm reading out from judgment. Normalization may be applied. Last page. Normalization may be applied.
Paragraph number?
Paragraph 10, just above, end of the paragraph 10. Next page,
Yes.
Please turn the page. Normalization may be applied and adopted in exceptional circumstances, but not in a routine manner, year after year. It is an exceptional circumstance in the previous case. So therefore, this can be allowed. And respect has been Lordship with humility, the writ court will not see it as a court of appeal. Anything, no case of malafide against the commission. Malafide did it, favoritism, but do something. No case of malafide. And what did again? They gain nothing, but they want to nullify somebody who has participated in examination. This judgment of Supreme Court is a interim order amending in the facts of that case, confined to facts of that case. It doesn't lay down the rule of law. On the other hand, says, it can be done in exceptional circumstances. But even then, the writ petition, on this writ petition should be dismissed, dismissed, because of necessary facts, because of Supreme Court. The party will be affected and not before a lordship. Those are humble. So, I'm grateful to my lord to be patient with me.
Who else will argue in support of Mr. Time is not. You will only you will argue. Any other counsel, you will also argue.
Only cover the points which are not covered by my letters.
No, that I say while adopting the argument of Mr. Mitro, Mr. Bhattacharya will argue, and you are also Mr. Bhattacharya. Chatterjee will argue.
Mr. Bhattacharya must be contributing something.
So no, I'm thinking whether we'll fix a 1 date or 2 dates. That I intend to know. And Mr. Thor will reply. Reply, you will be confined only to the law points, sir. So tell me, I'll fix 2 date or 1 date.
I will take not more than 45.
45 minutes.
45 minutes.
Very good, very good.
Don't.
It is not the
Yes, Pulanu Asun.
May I Maila's leave to release from the matter? I may not appear in.
But I have to hand over that.
Justice thinks
This is the original.
if Maila has got any query from Maila got any query from me, please send for me. I shall come and. Otherwise, not my. It is not kind deep to be. You have different procedure.
Mr. Dhar,
10:30.
The fourth, there is a.
second now?
Only thing fourth, her marriage ceremony that on that time she was so that's the kind. So initially I would have said
No, it's all right. It is absolutely genuine ground.
yes, yes.
For sufficient ground for extending the date. জন্ম মৃত্যু আর বিবাহ এইটা কারো হাতে
or we skip to next week.
No, sir.
সেখানে তার হবে না তো।
Then দেখো তুমি দেখো
18 জুলাই।
Because
তুমি এই উইকে
আমার তো
1 and 2 that primary is already fixed, that 32,000 আপনি তো ওখানে
আমাকে এবার বলতে হবে
হ্যাঁ এবার আপনার
First July না কবে আছে?
1st July 1 হ্যাঁ that's
ঠিক আছে।
হ্যাঁ মানে 1st July that primary matter
মর্নিং এ করে দাও আমার দুটোর সময় তো
হ্যাঁ আমাদের
মর্নিং এ করে দাও
মর্নিং কোনো অসুবিধা নেই হ্যাঁ মানে না even 1st July in morning no problem I say oh আচ্ছা কবে yes fine
you will finish on 30
no first in the first half no difficulty but first from second half that primary that matter will continue.
Mr. Bhattacharya
30th
Hasta.
मतलब 30th
তোমরা এগুলো কেন একটু অ্যাকোমোডেট করো 30 June
adopting the argument of I would adopt the argument I would think that Act also
On that day, what's Mr. Bhattacharya finishes?
July.
অসুবিধা আছে কন্টিনিউ হ্যাঁ ফার্স্ট জুলাই হয়ে যাবে
first
second half already matter is
বিকজ বলার কি আছে
হ্যাঁ no
ফার্স্ট জুলাই ফার্স্ট হাফ
এটা
ফার্স্ট জুলাই অলসো ফার্স্ট হাফ
30 লেখুন ওটা 3 দিন হয় ওটা ওটা দাও গো কল্যাণ বাবু দাও না
The original,
একটু বলে দাও
if Lordship wants to check.
give me the xerox হ্যাঁ Mr. Mitra,
Sir, may I, without saying, I had a great pleasure in arguing with Dr. Miller. Please accept my.
it is a learning for the court also, sir.
No, not. And please, Miller, if I may keep up the habit of telling the client, counsel, I have understood your point. What is the next point? Please keep up. This was done in old days.
Absolutely.
That will shorten the process.
Very good.
Sir, may I take my just kindly?
Prior to commencement of hearing, Mr. Dhor, learned senior advocate appearing on behalf of the appearing on behalf of the commission has filed 3 sets of question papers of the written examination as held on 29/5/2011. Why 3 sets, Mr. Dhor?
Because earlier there were separate question papers in 2 separate sessions. So very point that level playing.
No. This question paper are of the written test.
This question paper of 2011 and that contains 2 sets, and question paper of 2024 that contains 1 set.
Oh, I see. No, at the time of commencement of hearing, (29/5/2011) and 1/9/2024. Start. Let those photocopies of question papers be taken on record. Stop para. This court has heard Mr. Mitra, learned senior advocate, appearing on behalf of the writ petitioners in WPA 845 of 2025 in full. Stop. Let the matter be listed again. Let the instant matters be listed again on June 30 and June 30, 2025 and July 1, 2025. ঠিক বলছি তো? June 30, 2025 and July 1, 2025 with the mark 10:30 AM. Very good, sir. You take 45 minutes, 45 hours, but I will not allow you to argue on the same point. That very good, sir.
For reply.
30th June and 1st July. By 1st July, I am to complete.
Yes.
So your lordship rises, lordship, this is the Jalpaiguri matter which is to be tagged with these matters. It was.
So where are you, madam?
I apologize, your lordship. I came late. I am so sorry. I am.
Jalpaiguri. This matter is identical, no?
Yes, your lordship.
Stop.
Identical.
তাহলে ওই ম্যাটার পিটিশনটা দিন তারপর লিখুন প্যারা দিয়ে লিখুন considering the fact that WPA 230 of 2024 is identical with the instant matters, let the file of WPA 230 of 2024 be also tagged with the instant matters. You are in which side?
Petitioner, your lordship.
Oh, you are in which side? 2011 side or 2024 side? That you don't know. ব্যাকের জলপাইগুড়ি ম্যাটার লিখে রাখো জলপাইগুড়ি সার্কিট বেঞ্চ ম্যাটার একটা লাইন লিখে দেবেন তো in view of the assignment of the Honorable the Chief Justice.
I am for the state, my lord, in Jalpaiguri matter.
Yes. Give your appearance.
My lord. My video has been disabled, my lord.
You're audible, sir.
But the chat is also disabled. একটু চ্যাটটাকে অ্যাক্টিভেট করুন, এনেবল করুন।
I'm not the person.
কি বলবো? চ্যাটটাকে ডিসেবল করে রেখে দিয়েছিল, এত ওস্তাদ না সব।
Only one supplementary link, one matter. Matter is
Who is appearing? Your matter will not be taken up. The contempt matter, no? It will be taken up on Monday. That I watched.
She's there from the morning itself.
It has been done.
Yes, yes.
Very good.
Fresh resolution has been adopted. Hearing have been given. After that, fresh resolution has been adopted.
Very good. The personal rule has not been issued, no?
Lordship directed them to appear on virtually. Rule was not issued exactly. She's online. She's online.
সে নিয়ে আসেন ওনাকে
একটু ঢুকতে দিন না, একটু ঢুকতে দিন। হ্যাঁ হ্যাঁ, অপর্ণা মৌলিক, অপর্ণা মৌলিক।
দিন তো
হ্যাঁ,
don't file anything today.
very good. As the Lordship pleases.
The personal appearance of SM Aparna Maulik, chairperson. Madam, you are here.
Yes, my lord, I am here.
The personal appearance of SM Aparna Maulik, chairperson, Borno Municipality, who is present today in virtual mode, is noted, and her personal appearance through virtual mode is dispensed with for this day. Stop para. For paucity of time, the instant matter cannot be taken up today. Stop para. Let the matter be listed on June 30, 2025 under the same heading at the top of the list. It will be the first matter.
On that date, I'll file this.
No, I
Grateful to Lordship.
yes, call the Andaman matter.
My trouble.
Yes, madam.
My lord, I appear on behalf of respondent number 1 and 2, my lord.
Who's for the petitioner?
My lord, I appear for the petitioner, my lord.
Yes, madam Beni.
My lord, Here, my lord, the kindly see page 17, my lord. I am the recorded tenant. I am the recorded tenant. On the basis of my complaint, page 17 is the stay order, my lord.
Give me a second. What is the name of your client?
My lord, Amia Bakshi, my lord. Survey number is
Amia Bakshi.
132/2/2.
Yes.
My lord,
Very good.
this is the
What
stay
happened
order.
then?
My lord, this is the stay order. Here it is mentioned until demarcation. My lord, one
Did
fine
not-
date that is at page 18. Kindly be seen, my lord. Vacation order. Without demarcating, without hearing me, this order has been passed. Vacation order.
Yes.
My lord. So, my lord, without demarcation, without hearing me, without giving any opportunity to me, this order has been passed. Now, my lord, thereafter I have given, as soon as I received this vacation order, I have given first letter on 19, and thereafter kindly see 20th also I have given the letter, but no work. Now they have not stopped the work. Now construction is going on. Page 22 kindly be seen. Page 22, 23. Now work.
What is 20?
Page 8. Page 19 kindly be seen. I have given again a letter. 20 kindly be seen. I'm saying restore the stay order because the work is going on. Your own order is there till the demarcation. Let the demarcation may be done. Thereafter, my lord, it can be fixed. If the land, because it is joint land, the encroacher is the adjacent plot order. She is authorized my land. So I am saying let the demarcation be done. Everything will be clear. Till that time, no work should be complete done.
With for the private respondent.
My lord, private respondent, I have served the copy. I have already dispatched it, my lord.
Dispatch. Its service has been affected.
My lord, it's dispatched on, my lord, it was through speed post dispatched on 23rd 23/6, my lord.
So where is your affidavit of service?
My lord, it has not been delivered.
Then,
my lord, but the thing is that, my lord, the Tahsildar, because of the activity of the Tahsildar, this has been done, my lord. Because stay order has been given, due to stay order, no work was going on. In the meantime, before vacation order, the demarcation should have been done. After demarcation, let them do whatever they want, my lord. But the demarcation should be done to both the parties, both the survey numbers, so that everything will be clear, my lord.
When the circuit bench will start?
My lord, from 30th, my lord. From Monday.
30th June?
Yes, my lord. 30th June, my lord.
Yes, what is your submission?
My lord, I appear on behalf of the administration, my lord. On instruction, I am submitting, my lord, the private respondent, she is making her construction on her land, on her recorded land. Because the petitioner is having the landed property which is classified as house site. But Nasima Bibi, who is private respondent, my lord, her landed property has been classified as commercial land. And it's a little far from the land of the writ petitioner, my lord. And this private respondent is making her construction on her recorded land, my lord, as per the information given by the area patwari, my lord.
Take down.
My lord, the patwari, after seeing the field, it can be verified without
Listen,
demarcation.
listen to my order.
My lord, my lord.
The writ petitioner and the respondent, Andaman and Nicobar administration and its functionaries, that is the respondent number 1 and 2, are represented by their respective councils. It is submitted by M.S. Vini, learned advocate for the writ petitioner, that though notice has been served upon the private respondent number 3, but the track report shows that the service has not yet been effective. Stop para. In course of her submission, MS Vinny further submits that since circuit bench is not available now in Port Blair, and since the same is scheduled to be commenced on from June 30, 2025, and on account of extreme urgency, she is constrained to approach this court by filing the instant writ petition, praying for interim stay of unauthorized construction over plot bearing survey number 132/2/2/1 of School Line Village under Vijayapuram Tehsil, District South Andaman. Stop there. In course of her submission, MS Vinny at the very outset draws attention of this court to page number 17 of the instant writ petition.
That was my lord, page 18, my lord, the stay order has already been vacated, my lord.
Madam, listen to my order. Listen to my order.
My lord.
Please draw the attention of this court to page number 17 of the instant writ petition, being a copy of the order dated 22/5/2025, whereby and whereunder the respondent number 2 authority on the basis of a complaint made by the writ petitioner had called for a report from the revenue staff and directed the private respondent to stop all construction activity till demarcation of the said survey plot. Till demarcation of the said survey plot in question. It is however submitted by MS Vinny that however all on a sudden day on 12/6/2025 the respondent number 2 authority vacated the earlier order of stay without on the basis of a purported field verification, without giving any opportunity of hearing to the writ petitioner, and taking advantage of the same, the private respondent is making construction over the said survey plot. Full stop. It is submitted by MS Vinny that considering the extreme urgency of the situation, a stay order may be passed directing the private respondent number 3 not to proceed with any further construction over survey number over the plot of land bearing survey number 130 over the plot of land as mentioned supra. Stop there. Such contention is however opposed by MS
Babita Das.
Ms. Das, learned advocate, appearing on behalf of the respondent number 1 and 2. It is thus submitted that no case has been made out by the writ petitioner for obtaining even an interim order of stay. Stop para. On careful consideration of the entire materials as placed before this court, and after hearing the learned advocates for the contending parties, and keeping in mind the urgency of the situation, this court is inclined to allow the prayer for interim stay as made by the writ petition. Stop para. It is ordered that let there be a stay over any construction activity. Let there be a stay. Let there be a stay. Let there be a stay on any construction or activity over the plot of land being survey number 132/2/1, 132/2/1 at School Line Village.
One more survey number is there, my lord. 132/2/2. Two survey numbers, adjacent plot holders, my lord. They are the
Where the construction is going on.
132/2/2. That is my record.
132/2/2/2.
2, my lord.
তাই করে দাও। At School Line Village, under Street Vijayapuram, Tehsil, District, South Andaman, till the last day of July or till further order, whichever is earlier. Let the matter be placed before the available circuit bench on July 3, 2025, under the heading adjourn motion. Stop para. Learned advocate for the read petition is hereby directed to communicate the server copy of this order to the private respondent number 3 by speed post, and to file affidavit of service before the available circuit bench on the adjourned.
Highly obliged, my lord. Highly obliged, my lord.
Server করতে হবে, of course. Bear just a minute. Before parting with, it is further directed that the respondent number 1 and 2 authority shall ensure that the order as passed by this court is duly implemented in letter and spirit.
Much obliged, my lord. Much obliged, my lord.
কল করলেন একবার। এটা কি আছে? অন্য কোর্টে। আচ্ছা আচ্ছা। এটা কি আমার কোর্টে? হ্যাঁ, সে কোথায়? ওগুলো কোথায়? It is of my court.
Honorable Justice Parthasarathy Chatterjee.
হ্যাঁ, তাই বলছি। তুমি কি বলছো? বুঝতে পেরেছি। কোঅর্ডিনেট বেঞ্চ।
Firstly, my apology, my lord, for giving your lordship the trouble to take this matter so urgently. But
June 30, 2025.
Yes, your lordship.
I appear for the bank.
My lord,
I appear for the Reserve Bank of India.
only two things, my lord. We are just filing our affidavit in reply to the opposition filed by the bank, my lord, and praying for the extension of the last order dated.
The extension I'll be opposing. 10 crores are due unpaid. They have challenged, Lord, branding of Lord this account as a NPA. They have given us a proposal, Lord, for one-time settlement for 5 crores.
Mr. Mukherjee, this is not a regular bench.
But I understand.
Let me extend for 7 or 10 days. Liberty to mention before the page having determined.
My lord, on behalf of Reserve Bank, my lord, that affidavit could not be filed, my lord. Kindly give me
Sir,
liberty.
no, I will not do.
My lord,
Liberty to mention before the appropriate bench. Asun.
May I file my reply, my
my lord,
lord?
kindly record my
If it can be
submission,
taken.
Not today.
My lord, I am for the respondent number 11, 12, 13.
Time for the matter relating to encroachment of PWD's land. But is the affidavit of service?
Any report is there, Mr. Day? Very good. The affidavit of service as filed today is taken on record. The read petitioner, comma, the respondent state and its functions. That is the respondent number 1 to 10. And the private respondent number 11 to 15.
My lord, 11, 12, and 13.
Oh, private respondent 11, 12, and 13 are represented by their respective counsels. Stop here. At the time of hearing, an advocate for the read petitioner submits before this court. There is a specific case of the read petitioner that read petitioner or read petitioners?
Read petitioner.
Only
one.
One. It is this case of the read petitioner that he is the owner, recorded owner of plot number 99 and 101. He is the recorded owner of portions of plot number 99 and 101 in Mouja, Tentulia, TNTULIA, under PS Agra. It is further submitted that on account of illegal construction, it is further submitted on behalf of the read petitioner that on account of an illegal construction at the instance of the private respondents encroaching PWD road, that is Agra to Jhalda, in front of the read petitioner's aforementioned lands, the read petitioner is facing difficulty in getting easy egress and ingress to his aforementioned two plots of land. Stop. It is submitted that by way of representation dated 18 to 2024, such illegal activity of the private respondents have been brought to the notice of the respondent number 6. However, the said respondent number 6 had done nothing as yet. Stop para. Such contention, stop padding. It is a submitted that appropriate read or deed may be issued against the respondent authorities. It is submitted that appropriate relief of the reliefs will be granted to the read petitioner in terms of the prayer made in the instant read petition. Not today.
'82, my lord, I am appearing on behalf of the petitioner.
Mr. Botobel. No private respondent, I believe.
Yes, private respondent is there. Copy has
Service affected.
Service affected.
Fold the relevant track report. Ugilovke din. Saraswati Bala. So service upon the Saraswati Bala. Accepts same value stamp. Yes. Very good, sir. What is your prayer in the writ petition?
Prayer in the writ petition is for issuance of certified copy upon giving the value of stamp paper which has been the ADSR apprehended that court as per direction of the Honorable Division Bench of this High Court. The case is, my lord, in the year...
It is pertinent to Group 1.
It is pertinent to land, the deed of sale in...
Very good. Please the case.
Group 9.
Huh?
It by the return of the certificate and issuance of certified copy.
What is your prayer? I fail to understand. To accept the same valued stamp paper, will you kindly place the prayer?
Yes,
Yes, Lord. Simply hear the order. Yes, because my lord, the land it is connected with the land.
It is the connected land. The prayer is, my lord, respondent mandamus commanding the respondent authorities, particularly the registering authorities, additional district sub-registrar Hotatganj, district North 24 Porganas, being responsible for any accept same valued stamp paper and or amount in demand draft from the petitioners, so that make the good of loss of the government for the said registration process allegedly on the fourth stamp paper after completing the registration in terms of
according to the registering authority, the stamp paper which has been submitted at the time of execution of the document is forged.
Apprehended that forged. It is not.
So what do you want now?
I want the certified copy of that particular registration in terms of the division bench order, where kindly in terms of the
document has been registered.
Document has been registered, but ultimately it has not been returned to the petition.
Very good. Please, the document has been tendered for registration.
Registration.
According to you, it was with adequate stamp duty.
Adequate stamp paper.
According to the registration office, the stamp paper which you have filed are found to be allegedly fake. Then what happened? So then the registration is not complete.
Now, in terms of the division bench order, the process of registration has been complete. But
so how it comes under the Group 1, sir?
It's relating to land, transfer of land.
But no relief has been sought for in respect of land.
In earlier occasion, my lord, Honorable Justice
Very good, sir. Place the judgment. What judgment has been placed?
Sir, একটুখানি judgment. একটুখানি দাও, আমি দিয়ে দিচ্ছি.
Will you kindly place, sir?
Yes, ma'am. Page 2, my lord, the operator. On depositing an amount, para 3, my lord.
Yes.
On depositing an amount equivalent to the aggregate value of the stamp papers used for the purpose of registration with the registering authority, and upon proper application being made for obtaining certified copy, and on payment of proper fees for the same, the registering authority concerned shall supply the certified copy of the document. The said certified copy shall be used for the all practical purposes. Supply of certified copies shall be made within fortnight from the date of making deposit. And the there is a particular direction, and the aforesaid amount shall be kept deposit till the investigation is complete and the trial is over, ideally in a term deposit if possible. And from the page number 1, my lord, last paragraph,
Now, what happened after passing of this order? What happened?
petitioner went to the office of the concerned ADSR, and ADSR specifically verbally already directed either order of a order from the honorable court. They are not going.
So, what is your case? After passing of this order, investigation has been, inquiry has been taken.
Inquiry, the case is, my lord,
Inquiry was done.
inquiry was done.
Very good. What is the outcome of the inquiry?
Still, the criminal case is pending. Criminal case is instituted.
No. What would be what was the fate of the deed which was presented for registration?
Kept as before the ADSR as seized.
So registration has not been completed.
The order of the division
What
bench.
is the outcome of the inquiry, sir? Kindly tell me. The inquiry authority found that it was forged.
No.
Then
investigation is still going on, and the connected criminal case is still pending.
Sir, I am not concerned about the criminal proceeding. Sitting in lead jurisdiction, I want to know what is the outcome of the inquiry report regarding the genuineness of the stamp.
That is not communicated to the petitioner, mind.
Then what do you want?
I want the certified copy.
Certified copy of a document you will get. Certified copy of a document you will get only on completion of registration of that document. Unless and unless registration is complete, how do you get the certified copy?
My lord,
Mr. Bandyopadhyay, submit a report. Report is there. কি আছে? In connection,
It's not clear whether the registration is complete or not. দাও নাম্বারটা দাও না, আমরা বার করে নিচ্ছি।
এইখানে
কপি জানলে কি হইবে?
আমি আপনাকেই দেবো।
order. Is this thing? Simple major order তো।
Recent major order.
এই তো, সিরিয়াস এমনি তো 50 হয়েছে। অসীম কুমার।
সুদর্শ মাইতি। আশুতোষ মাইতি।
কি নাম ছিল এটা? সিস্টেম নাম জানি না। হ্যাঁ।
My lord, the registration process has been complete and the deed number has already been given.
Yes, that I see.
Yes.
That I have seen. Ashun, that I have seen.
83, my lord, I am for the petition. It's a very short matter. Could I purchase the property, had it mutated?
Give me a second, sir.
Lordship.
Yes, Mr. Mukherjee.
Could I purchase the property which is abutting, my lord, allegedly a forest land? It is not a forest land, but abutting a forest land. So, my lord, after I purchased, my lord, the mutation was made in my name. It was classified as a danga. And my lord, when I went, my lord, to build the boundary wall, there was an existing boundary wall. Something has fallen. So I wanted to rebuild the boundary wall. My lord, the officials from the forest department came and said that, no, this is a part of a forest land. So, my lord, I came up before this honorable court. This honorable court passed an order that there should be a demarcation in terms of CS record of rights and CS map. Now, the difficulty is, my lord, the CS, as your lordship knows, my lord, it is, my lord, of the year 1934-36. My property mutated in terms of RS. Everything now is in terms of RS and LR. All that I pray is that the authority is to demarcate in terms of not the RS and LR.
That can't be. As because, my lord, Forest Act, according to the Act Forest, that was declared, my lord, according to the CS block. And my lord, page 80, if your lordship will see, previous order. That order was not modified or anything else. Or appeal is not filed against that order. So now he can't pray for RS and LR. My lord, your lordship can pass this order that the additional district magistrate, district land and land reform officer will survey the demarcate the lands in CS map according to the previous order within 3 months.
So demarcation has been done?
No.
I'll just kindly have a look at the first portion of this order. Since my learned friend says that nothing can be, it is submitted on behalf of the petitioner that during the pendency of the writ petition, it is my submission being recorded. The Divisional Forest Officer, Kongshaboti North Division, Purulia, has requested the additional district magistrate and district land reforms officer, Purulia, to survey and demarcate the land in question in terms of the CS map and gazette notification provided to it. Now, Lord, this was, Lord, my submission.
So demarcation has not been done by Mr.
So
Dey.
demarcation should be done according to the CS map. As because, my lord, forest is declared according to the CS record of rights, CS plot. So now, my lord,
In respect of forest land CS map,
yes, my
CS
lord,
plot number is still prevail.
yes, still prevail. And forest, my lord, was declared and all the things was according to CS map. Now, my lord, there is some why my learned friend, my lord, wanted to now forest, my lord, if some person, my lord, encroached or anything else or other things, my lord, and so previously, my lord, in the
So
year
Mr. Mukherjee, let demarcation be done.
I want that demarcation, my lord. I cannot proceed. My learned friend has given mutation. Your lordship will kindly have a look at mutation. Now, my learned friend says that there is an encroachment to the forest. He says so without a demarcation, by assumption. Now, my lord, the classification of the land that they have, my lord, done is a danga land, not even, my lord, jungle forest. At page, my lord, 77. Lodge. I'm grateful.
But this is my affidavit of service.
I am appearing good.
Any private respondent, Mr. Ganguly?
The petitioner is
Respondent, private respondent is there? Give me a second then. Yes, sir.
The petitioner is owner of a tractor, Malad.
Tractor?
Yes. Because now he was carrying 100 square feet of sand. The land reform authorities intercepted the tractor, saying that the sand was illegal. He was not flying in the designated route. As such, the tractor was seized.
It was not. It was not
flying on the designated route. But this was the grievance, of that. Now, it was seized. I paid for return of the vehicle from the CGM. The CGM said, you pay 1 lakh of rupees and take return of the vehicle. And where that order was passed, the authority filed one application, put up application in that court, saying that you are not the authority to adjudicate this sale. The authority under the act will, calculate the fine which has to be imposed on the petition. The authority, if your lordship kindly come to the penalty part, at page 49. Since there is a provision for compounding of that offense, kindly come to the from the second paragraph, the operative portion. The case being number such and such has been disposed of by the authority empowered under section 4182124 of the Mines and Minerals Act and BLR of Bakuda after compounding the offense to the owner of the vehicle being number such and such as per provision of the Act of the West Bengal Minor Concessions Rules in terms of the penalty amount of rupees 1 lakh and it would be credited to the appropriate head of the account, Government of West Bengal, offender namely Jahrul Khan. The owner of the vehicle has been directed to pay the penalty and then the vehicle will be released. But the said vehicle, but the owner of the said vehicle, Jahrul Khan, did not deposit the penalty amount of rupees 1 lakh at the appropriate head of the government of West Bengal till now. So if the vehicle is released without pay the penalty, it will cause huge loss of the government revenue. So the appropriate authority have strong and vehemently without the pay and penalty as ordered by the appropriate authority. So this was the order, was passed by the empowered authority. Challenging that order, an appeal was preferred. We'll find at page.
The proceeding was initiated under which act or which rules?
The Mines and Minerals Concessions Rules as well as the Act.
1957 Act?
2016. It was later on, there was an amendment.
So it is a case of the year 2019.
19. Initially,
then what happened?
Thereafter, we preferred the appeal. Now we came before this Honorable High Court, at page 93, we'll find.
No, challenging this order where we have approached.
To the Honorable High Court, the Honorable High Court said that this is not the appropriate authority. We have to approach before the Appellate authority.
Who is the Appellate authority?
The Commissioner.
Commissioner?
Yes. Page 91, that order, will find.
That order is under challenge.
Thereafter, there is a provision for review.
Achha. So what is the Appellate authority?
Order of review is under challenge.
Very good. Then what Appellate authority had?
Appellate authority, affirmed the order, which was passed by the empowered authority. Page 91, we'll find that. Now, liberty was given by this Honorable High Court that I should approach the appropriate, my lord, authority for my grievances. So, my lord, my appropriate authority after the appeal was dismissed.
No, appellate order is incomplete.
Page 91, my lord.
Just see, there's no sequence. After 91, it is 92. Where is the full order?
No, madam. It starts with 5 January 2022.
So what is the finding of the? What is the finding of the appellate order?
Kindly come.
Incomplete documentation.
No. Madam, this is the document.
Sir, place. Considering all the points,
my lord,
first, second, third, fourth paragraph.
Case is taken up for hearing, my lord has seen. First paragraph. Thereafter, my lord, considering all the points as raised by both the appellant and the respondent of the undersigned, the instant appeal is rejected and disposed of on the basis of the following points. The appellant completely deviated from the ground of appeal as his primary intention was to release the tractor. He was directed to deposit the amount as per reasonable market value for the same, which he did not comply. BLRO given him the opportunity of being heard in the very next day just after the date for the sake of natural justice, but he completely avoided that route. Thereafter, he filed an appeal to the CGM court, where the learned judge judicially ordered him to go through the BLRO concerned for being the appropriate authority to judge the sale. So, my lord, he says suppressing the facts.
Actually, your contention is that since you have a valid challan for carrying out, it was completely on the part of the to fine 1 lakh from retention.
100 square feet of, my lord, sand I am carrying.
So you are challenging the correctness of the finding of the authority. Very good. Then what happened?
Thereafter, my lord, my remedy was to file a review. The review.
An appeal and complaint.
Then page 94 is my review, my lord. Now, there was a delay in filing the review. The my lord, commissioner, my lord, on the ground of delay, my lord has rejected my review petition. Page 98 is the order.
So what do you want?
My lord, I want, my lord,
remission of quantum. I understand. Who is for the?
Lordship, kindly see, my lords, section 58, within 30 days, they have to, my lord, file a petition.
Technicalities, my lord. The quantum of, my lord, 100 square feet of sand, my lord, and for 5 years I am suffering. 1 lakh of rupees, my lord, is exorbitant.
আসুন ভাই।
Mr. Saha, 75,000 bonus.
কারেকশন করতে হবে।
এই দাও গিলোকে দাও একটা কারেকশন।
রথযাত্রা বোনাস।
রথযাত্রা এরপরে পুজো আরো 100% হয়ে যাবে। Deep no oblige, my lord.
In this matter, I am for the petition. This is my affidavit of service, my lord.
Any private respondent is there?
Yes, yes, all received.
How many private respondents?
There are
8 to 22.
8 to 22.
8 to 20?
Yes.
8 to
Service
22,
affected?
my lord.
Yes, affected, my
Upon all?
all.
Unauthorized encroachment?
Yes, my lord, I'm grateful to lordship. Annexer P2.
Highways Act 1964?
Pardon, my lord?
Highways Act 1964?
Yes.
Ashun. The affidavit of services filed today on behalf of the writ petition is taken on record.
Number 86. 86 Milord, I am petition. Affidavit of service filed on earlier auction, that is on 20th June 2024.
It was appearing for the first time. No previous order is there.
There was the
Yes,
matter
affidavit
was
of service
appeared in
there.
the earlier occasion before the Honorable Justice Gaurang Kant,
No.
and I have filed on that time affidavit of service. This matter.
Yes, yes, it is there.
This
Service,
matter-
is there any private respondent?
Yes, Milord.
Affected?
Yes.
Then survey fresh notice, sir. Who is for the state?
Mr. Supratin Dhar and Devopriya Sarkar. I have served notice before mentioning. This matter relate to unauthorized encroachment.
Very good, sir. Serve notice once.
Lordship, I am led by Mr. Devjit Mukherjee in this matter.
Today. Not today.
Grateful, Lordship.
Grateful. How much time will you require? No, sir. I have a division bench. That is
I will be there. Very short before the division bench. What happens, my lord?
ইদাও তো ফাইল হবে কিনা জানি না বাবার মধ্যে
ছোট মানুষ মাইলরের ডিভিশন বেঞ্চ
হ্যাঁ বলে দিচ্ছি मतलब I have my renewal deed was registered on 2019, but the state authority has challenged before the Supreme Court against the division bench order. But what happens, my lord? Come to page 19. Supreme Court has dismissed.
So it will take some time.
No, very short time.
I have a division bench. It will be taken up tomorrow, sir. Whatever. I don't have any.
Monday.
tomorrow তো নয় ওটা ফেরত দিয়ে দিন মানডেতে থাকবে
চলো আমরাও যাই
হয়তো মানডে এটা বলে দিচ্ছি
এটা দিয়ে সিঙ্গে কোনো ফিক্স মোশন আছে মন্ডেতে ফিক্স মোশন আছে কটা আছে
ফিক্স মোশন থাকবে তো মানে
let me ascertain sir I'm thinking about your interest চারটে তো এটা 5 নম্বরে দিয়ে দাও ফিক্স মোশন আইটেম নাম্বার 5 থাকবে